May I please, sir? I'd like to mention an unlisting matter may be taken up today along with item number 24.
Unlisted matter?
Yeah, both are same. They both are on the same FIR.
Which item?
24, madam.
Huh?
24.
Okay.
Oh, bless you.
May it please your lordship, respectfully seek adjournment for item number 55. Adjournment for item number 55.
55.
Yes, your lordship. Kindly list it after 1 week.
What happened?
Senior counsel is not in position to appear. Health is not put.
Hmm?
Senior counsel health is not put.
Okay. It's on the prayer of the learned counsel. Your name?
Shrin Kashi.
So and so we'll have praying for adjournment of the matter. Let the matter be listed after a week.
Yeah, lordship, here in this case, lordship, the petitioner was arrested on 14/5/2026 and as on today, lordship, 95 days. As on today, lordship, 95 days is in custody. Lordship.
Okay, heard so and so the learned counsel appearing for the accused applicant also heard Mr. R.J. Burwal on an AP for the state. This is an application under so and so call for the CD. Let the matter if it's done.
Lordship, lordship, sterile period is 90 days, lordship.
90 days.
Lordship. Today, as on today, lordship, 95
You tell me beforehand.
lordship,
You are
95
not saying 90 days statutory period.
lordship,
Today is 95 days.
95 days.
You take instructions.
Yes, yes.
We'll pass it over for time being. Huh? This one.
May I please, your lordship? The 483 application, your lordship, the accused person was arrested on 26/7/2026.
Hmm.
And till date, your lordship,
When he was arrested?
he was arrested on 26/7/2026.
26/7.
26/7.
Yes.
And he has sent to judicial custody on 28/7/2026, your lordship. FIR at page number 15. The contents of the FIR is that, your lordship, the informant has defaulted to pay the EMI amount to the and the accused person is a recovery agent. However, the said informant alleges that he has take away.
We'll see the CD in this case.
The thing is that, your lordship, the
But
informant.
you have assaulted. I mean, you started threatening
No, Your
people.
Honor.
I mean, that is the allegation. So
allegation
the allegation will be there and we'll see the CD on the basis of it. We'll see whether the allegation is correct or not. Then only we will consider.
Yes.
Because you being a recovery agent, you cannot threaten people and like assault people
No, Your
only
Honor.
because somebody has defaulted.
Yes, sir.
That you cannot do. So that's why we call for the CD.
Okay.
Heard Mr.
S0, Your Honor.
SD Roy, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwal on a AP for the state. Is an application under so and so. Call for the CD. Let the meter be fixed on 27th August, 26th August.
Not
Which this is from where? Tihu.
TU, Your Lordship, Nalvaris.
Today is 18th and is okay. 26th.
Lordship. March
26th. 26th.
This is a transit bail application, my lordship. The petitioner stopped the notice, my lordship, under section 35, close bracket 3, my lordship. The page number 14 is the notice, my lordship. And he has to appear within 2 weeks, my lordship. And my lordship, actually, my lordship, she works in the Anganwadi center, my lordship. So she works in Anganwadi center, my lordship. She'll go there, my lordship.
Where?
It is Bidhannagar police station, West Bengal, my lordship. Page number 14, my lordship, the notice, my lord. Page number 13, my lordship, 1-3.
So you go there.
My lordship, I go to the thing, my lordship, what is in here, my lordship? Earlier, 30/01, they have served the notice, my lordship. I've sent my son because I'm 53-year-old lady, my lordship. So my son went there, they said that your mother should come, my lordship.
Yeah, you go there, you go, I mean, why do you need a bail on this?
My lordship,
It's a 35(3) notice, you
my
go there.
lordship, during the interrogation, my lordship, I can, without a warrant, my lordship, I can, during the interrogation time, my lordship, I can arrest me without warrant, my lordship, as because date might be in the meantime will be finished, my lordship, because this is a 0-1, it is get 2 week time was given to me, my lordship.
Now 2 weeks is sufficient, you go there.
My lordship, already time is over, my lordship. Today is 17th, my
Why
lordship.
you have come late?
So, my lordship,
Who has asked you to come late?
my lordship.
Who has asked you to come late? Hmm? You'll sit tight and then
My
like
lordship,
you
similarly,
will come.
this honorable court has granted bail, my lordship. This honorable court given granted bail, my
So?
lordship.
So what, all facts are different?
My lordship, we have also got a notice on the 35 close bracket 3, my
Hmm.
lordship. There are 2 judgments I have attached, my lordship. One is 2026, one is 2000.
We are aware of
My
this.
lordship.
We are aware of this. But I'm asking is that like what is your apprehension? Why?
My apprehension, my lordship, my number is there with them. So while I will appear there, my lordship, they have tracked my number and they can get arrested with me, lordship. As the time is already over. And 35 close bracket 6, the lordship knows that whenever they have served a notice on 35 close bracket 3, if I have not obeyed that particular notice, they can arrest me, my lordship. My lordship,
Why have not you obeyed that notice?
my lordship. My liberty will be curtailed. I can be arrested during the interrogation. But transit also, my lordship, I can be arrested.
Liberty is curtailed without any procedure.
My lordship, during your transit, my lordship, they can arrest me. Humble prayer, my lordship, 53-year-old lady, my lordship. And she works in Anganwadi center, my lordship. That time, Anganwadi construction was going on, my lordship. That is the reason I could not be able to go there. Anganwadi working center, my lordship, construction is going on, my lordship. I also
Yeah, if you think construction is important, you will be there. You keep on doing construction work.
humble prayer, my lordship, may consider she being a lady, my lordship. Sir. Only 2 weeks time, maybe, given my lordship. I'll be glad to have my lordship.
Yes, yes, that sound well. Again, my lord, yeah, so my lord, again, my lord, notice was by the that is 1/8/2026, my lord, that is. That's it, we have these 2 weeks.
Wow, this
But
petition is
2 weeks also, my lord, there is no taken. And interim time, my lord, they are clear, because my lord, sufficient time, my lord. So approach my lord, appropriate courts.
my lordship.
So it is not like, my lord, he's paying properly, serious, still, my lord.
My lordship, my lordship, since petitioner herself will go, my lordship. And she being a lady, my lordship.
But question is that, my lord, he has already for sufficient time, my lord.
Okay, we'll let her appear there. Go ahead. Heard, Mr.
Aramin, my lord.
I mean the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwal and 3 people for the stage. This is an application under section 482 of the NSS 2023. With Article 226. Why 226 here?
मतलब liberty मतलब right to life and liberty. So Article 21 is involved.
Article 220 is a writ petition. You file writ petition then.
File this petition, my lord.
Huh? You file a writ petition then. Why you're writing 226 here?
My lord.
Huh? You file a writ petition, then this is, I mean, this has to be registered as writ petition. You are filing under 226.
Retired 482, my lord.
Now 226 you have added.
Yeah, but I did pay it with lordship.
They have also made with the party.
Notice has to go there.
Your lordship may send the notice in the meantime, the lordship side will be granted.
standing there, madam, no question of matter pending.
You better withdraw this and file a phrase. Why this SI is required? SI is not required. 226 petition, you are saying 220, but then it will have to be registered at WPC.
Well,
You can make a statement that like 226 is what? 226 is writ jurisdiction. So why you are writing 226 here? Your liberty will be, under 14, 16, 19, 21, 22, all these things. How 226 has come?
my mistake, my lordship. I apologize. my
You
lordship.
withdraw and
That's my
I'll file a
lordship, I
case.
concern them. That is why I,
Yeah.
lordship, I thought Article 21 is involved, right? So I,
226, how 226? 226 gives you something. 226, is there any fundamental, what is granted under 226?
At 56, basically the read petition. My
The writ
lordship,
jurisdiction, the file a writ then.
my lordship, what I-
You withdraw this and file a fresh.
my lordship.
Heard Mr. Sorensen Garnet comes appearing for the accused applicant submits that he desires to withdraw this instant. AB, we take liberty to file a fresh.
My lordship.
Uh,
Deep love,
this
that's
instant
my
AB application is dismissed and withdrawn.
May it please, your lordship. Here is the application, page 10 is the FIR. Page 10, 6 accused persons. I am for the petition number, request number 3 to 6. One is the husband. And all the petitioners are the in-laws of the victim earlier. All the petitioners, request number 3 to 6, all are the in-laws.
In-laws of who?
In-laws of
Informant.
the deceased yours.
Hmm?
Informant sister, deceased yours. They committed suicide by hanging. After that, all the family members will be declared. If all the petitioners living separately, but they are also implicated only to harass yours. 3 and 4 are the brothers, and 5 is the married sister. And 6, request number 6 is the cousin brother, also from different villages. Request number 1 and 2 are already arrested.
Case of Balgarup Singh.
Heard Mr.
Yes, sir.
S. Islam, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwal, learned AP for the state. There is an application under so and so, call for the CD. Let the matter be fixed on 2nd September.
Item 5.
It will shall of this. My lord, I file anticipatory bail petition, my lord. What happened, my lord? I have taken a loan, taken a vehicle on loan, my lord. And on being failed, my lord, as our relevant person is page 13. FIR in page 13, my lord. And my name is page 14.
Heard Mr.
M.
M. Singh, the learned counsel appearing for the accused applicant, also heard Ajay Borua. It is an application, then you write, call for the CD, and with the matter fixed on 7th of September.
Only my lord, interim protection may be given. My lord,
Is this a case for giving interim? No
my
interim.
lord, only thing.
No
is that-
interim.
My lord, I have failed to
No interim.
comply with the notice.
I have
my
passed the
lord.
order, no interim. I've seen it.
Lovely.
Item 6.
Wait, please, your lordship. Your lordship will find the FIR, my lord, at page, my lord, 9, my.
Yes.
I have narrated the fact, my lord, if the lordship turns to page 3, my lord, paragraph 5, my lord.
Now what happened to the girl?
My girl is returned back, my lord. Already, Jimma has been given to our father. My lord, paragraph 5, my lord, the petitioner begs to state the fact is that there was a love relationship between the victim girl and Abdul Batten, the son of the present accused petitioner, for about a year. The said relationship was known to the parties, and the alleged victim girl had voluntarily gone to the house of the present petitioner with the intention of marrying the son of the present petitioner. But the present petitioner did not support the consent to such marriage. Therefore, the victim girl returned to her own home from the house of the accused. Consequently, the informant lodged the FIR against the accused petitioner by leveling such false allegation. Well, the girl is with her parents, my lord. Now, if I'm depending on Chaudhary. Her statement was recorded before the magistrate, my lord. I had the copy but could not produce because it's not a certified copy, my lord. She voluntarily came, my lord, and she went back.
Okay, heard answer, doctor, the learned counsel appearing.
The victim was affected by not below 16 years of age. Technically, my lord, whether POCSO is not said to be verified through the case.
Correct, you verify it. You verify it. Huh? We'll call for the case there. We are giving him interim protection only. No, what submission, Mr. Borua? I'm calling for the CD and I'm just giving him interim. And I'm calling for the CD. What submission you want me to record? That you're opposing? Then?
Yes, ma'am. Without the city, I am opposing.
I'm saying that I'm just giving him interim for protection and we are calling for the CD. What do you want? What else you want?
My submission only, my lord, since the victim is below 16 years, my lord. It is necessary to Peruvial money.
So you produce it on the next date. If there is something, we'll cancel it. Third, Mr. N.J. Doctor, the learned counsel appearing for the accused applicant, also have Mr. Ajay Borua, learned AP for the state. This is an application under section 482 of BNS 2023, praying for granting PRS bill to the accused applicant. In connection, accused applicant in an application under in connection with Manipur PS case number 59/2026 registered under 87 of BNS, full stop. When we write an FIR was lost.
He is 9.
An FIR was lost by the informant on 19/7/2026, alleging interior death on 18/7/2026 at about 3 AM. when she woke up from sleep, she noticed that her minor daughter, namely X, was not present at home. That after searching outside at various places, the informant came to know that his minor daughter, who went outside to urinate at night, and taking advantage of the situation, the two accused persons had forcefully kidnapped her and confined her to an unknown place. On receipt of the FIR, police registered Manipur PS case number 59/2026 under section 87 of BNS. The learned counsel appearing for the accused applicant submits that the girl was produced before the SDGM as Bongaigaon on 23/7/2026, and she has already been handed over to the parents of the handed over to the parents. Full stop. In view of the aforesaid, he submits that the accused applicant should be granted PRS bail. Full stop. Mr. Ajay Bhagwan, learned counsel APP, on the other hand, objects to granting any protection to the accused applicant at this stage, stating that CD in the instant case shall be required. After hearing the parties, this court is of the considered opinion that the accused applicant should be granted some interim relief. Accordingly, it is directed that in the instant of in the event of arrest of the accused applicant by the investigating authority in connection with Manipur PS case 15/2026, he shall be released on interim PRS bail and furnishing of a bail bond of ₹50,000 with a severity of life nature, subject to the following conditions: that the accused applicant shall appear before the investigating officer within a period of 10 days from today. The accused applicant shall cooperate with the investigation and make himself available as and when required by the investigating officer. The accused applicant shall not temporarily hamper. When you write call for a CD, let the matter be fixed on 2nd of September,
I have to appear within 10 seconds.
within 10 days.
But I'm obliged, deeply obliged.
Item 7.
Yes.
Charge sheet file P76, my lord.
Hmm?
And P76 charge sheet already filed. And someone issued by the available wagon to arrest by the CGM. So only if the apprehension by once he appears to the committal court. So I'll appear matter, then your lordship may kindly consider the action. Then there is order page 27 or 2 you have given. Order on this point, my lord. FIR kindly see FIR my page 30. After 8 months, the case was allowed.
So we'll see the when you have been asked to appear.
Page 16, 9, my lord.
No.
Page 26.
Page 26.
Page 26. Variable wagon to arrest, my lord.
So you can go and appear.
I appear only protection matter because
Why
like,
protection is required, Mr. Chaudhary?
my lord, you're
Bailable
like
warrant.
in the light of page 27, man.
Hmm?
In the light of page 27. What are page 27? Of course, it is subject to your lordship's single bench order. Page 29. Last paragraph, points.
So you have appeared,
No, I have not appeared. No.
then
Here also same case, madam. Your lordship kindly
this is
see,
different case.
same point, but not same case, sir, same point. Page, start from page 28, my lord. It is submitted that the police never apprehended the present petitioner in the course of so and so, my lord. And the last part is page 29, last paragraph, my lord. I have considered so and so. It was 27. It is report is on. Report is on. Yeah.
Yes, Borwa.
This case, madam, they have released only the one order, madam, 37,020. After submitted, madam, in the year 2025. If it is the first order, madam, then case different. So, madam, person we don't want to submit case, madam. Then faithful
He was in Bangalore, my lord. It is true. Earlier also available warrant issued. He could not appear, my lord. When he was in Bangalore, my lord, security guard, he served in there. Now he is ready to face the trial, my lord. I think nobody will be prejudiced, my lord. He is ready, my lord.
Let him appear because this order has been passed. So he has to appear. So only thing is that he's asking for this limited protection.
This is the only thing.
Let him appear there. Then it will be considered.
It has been shown as a.
Hmm?
It has been shown as a.
That is why this, I mean, this warrant has been issued. Valuable warrant has been issued for that only.
No.
So once he appears there, then let the trial court take the decision on that. Third, Mr. H.R.A. Chaudhary, the Learned Counsel, Senior Counsel. This is the best to ensure the Learned Counsel for the accused applicant. This is an application under section 482 of the NSS 203, paying for 3 years bail to the accused applicant in connection with PRC case number 1150/2026 arising out of Karimganj PS case number 632/2024, registered under section 376 of Indian Penal Code, IPC. Full stop. An FIR was lodged on 12/11/2024 by the informant before the OC Karimganj police station, alleging earlier that about 8 months ago, the accused raped her on finding her alone near the village mosque. It was alleged that when she tried to disclose the incident to her family members and co-villagers, the accused person, alia, to marry her, promised to marry her. However, later, the accused person raped her multiple times with the enticement of marrying her. It is alleged that due to the acts of the accused, the informant became pregnant, and when she pressurized the accused applicant to marry her, he fled to Bangalore. On receipt of the FIR, police registered Karimganj police case number 632/2024 under the Financial Sections. Next paragraph. On completion of the investigation, the police filed charge sheet number 82/2025, dated 28/2/2025 under section 376 of Indian Penal Code against the accused applicant, citing 5 PWs in support of the prosecution case. Stop. The learned senior counsel. Submits that the accused applicant has been issued with a bailable warrant of arrest by the learned CJM by order dated 37/2026, fixing 16/9/2026 for appearance in connection with the present case. He submits that since the offense alleged is exclusively triable by the Court of Sessions, and a Court of Sessions, the accused applicant has reasonable apprehension of being taken into custody on his appearance under section 332 of BNS prior to committing the case to the learned session judge and CBN. He submits that the accused applicant was issued a bailable warrant earlier also. However, he could not appear because he was staying in Bangalore at that point of time. He submits that the accused applicant is very much willing to cooperate with very much willing to face the trial, and therefore at this stage the accused applicant should be given some protection so that he can appear before the learned Chief Judicial Magistrate on 16/9/2026. On the other hand, Mr. R.J. Bamburwa, the learned APP, submits that the case relates to heinous crime, and he has been absconding since a long time. He should not be granted any relief at this stage. This court has considered the submissions made by the counsel according to the respective parties, and it is still seen that though the warrant is of a bailable nature, however, the apprehension of the accused applicant cannot be ruled out due to the fact that the case is yet to be committed, and yet to be committed to the Sessions Court, and there may be some apprehension of arrest on his appearance before the CGM. Taking into account the aforesaid facts, this court is of the considered opinion that this instant AV application can be disposed of at this stage only with the direction to the accused applicant to appear on 16/9/2026 before the learned CJM. Sribhumi, CJM Sribhumi. CJM Sribhumi. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with
Yeah,
in
see,
connection with Corrigan's PS case number 632/2024 in bracket PRC case number 11502026. The accused applicant shall be released on furnishing of a bail bond of rupees 30,000 with a security of likeness, subject to the condition that the accused applicant shall cooperate with the trial and shall, subject to condition that the accused applicant shall appear before the learned CJM Sri Bhumi on 16/9/2026 and also cooperate with the trial. Full stop. In view of in terms of the aforesaid directions, the instant AV application is disposed of.
okay.
Then one. I have one.
Partial file man.
The person already considered 95 days.
Item one now.
Correct, 90, so 95, when search is submitted?
25/7.
25/7, he was arrested on
Arrested on my lord 14/5/26.
14.
14/5. Today 95 days back.
The thing is, the search sheet has already been submitted.
Within time it was filed, my lord.
Hmm?
So he did not have knowledge, my lord. We came to know from the co-accused what are my.
Correct, I mean, when search sheet was for, I mean,
Yes.
submit search sheet is, he's saying search sheet, it's submitted in time,
Submit-
within 90 days.
Yeah, I'm not, for default bail is not applicable.
Uh-huh.
Only for the merit 95 days charge to always file, my lord, but that is what I.
Then we'll see with the records what is there. What is his allegation? What is the allegation?
My attempt to murder, man.
Hmm?
Attempt to murder, 109, plus other sections are there.
But we'll call for the record, we'll see what is there. What
Okay,
Mr.
but-
Ittari Chaudhary,
It is from
that is-
Nalbari.
huh?
It is Nalbari short date, my lord.
Ittari Chaudhary, London Senior Counsel, this is there by I. Chaudhary, the counsel for the accused applicant, also heard Mr. R.J. Burwal and a plea for the state. There is an application under so and so, then you call for the CD. I call for, I mean, we'll have to call for the TCR in this case. Scale TCR along with the CD. The history to call for the scan TCR along with the case diary and let the material fixed on.
Nalbari, man.
Second of September.
Second September. October 3. Yes, some are, he's in custody, my lord.
Earlier it will be difficult. So many cases are there.
Ultimately,
Record will not come otherwise also most probably. Okay, we'll take a chance. 27, 27, please.
27.
27.
Right.
8.
May I please a motion? But in this case, FIR at case 11, my lord.
We'll call for the CD in this case.
My lord, in this case, I'd like to draw your lordship's attention that the alleged, my lord, offense of abetment, it doesn't come here.
Mm.
Only because, my lord, I have annexed photographs, page 22. Kindly find my lord,
What photographs?
page 22.
Okay, let us see then if you are arguing, let us see that.
I may be protected, my lord, in the
Then
meantime.
let us see the affair.
My lord, yes.
Mm.
Page 11, relevant portion, my lord,
It's a long affair.
yes. Page 15. It is long affair, my lord. Very bad.
Heard Mr.
Yes, serious, my lord.
Vigas,
I will
learned
report it.
counsel appearing for the accused applicant, also heard Mr. K. Bush. K. Bush, the learned APP for the state. Then you write decision application. Under section 482 of BNSS 2023, paying for granting bail to the accused applicant. Granting clearance bail to the accused applicant in connection with basis to PS case number 296/2026 under section 108/61 bracket 2 BNS. An FIR was lodged on laws on 5/8 no 4/8/2026 before the Bosista police station. Bosista police station by the informant alleging inter alia that his son was in a love relationship with one girl. Oh, they measure, no? She's a measure.
Measure.
Hmm? One girl named Asmita Das. Smita Das for a considerable, since a considerable period of, no, since for a considerable period of time. It was alleged that, that his son as well as the aforesaid Smita Das were in a relationship, and the same was known to the family of the girl. Family of the girl. It is alleged that the brother of the girl it is alleged that the family of the girl is not in favor of the relationship of the girl with the victim, with the deceased boy, especially the brother, the other Sri Vicky Das, the accused applicant. Who keeps on treating the deceased boy with dire consequences if he does not stop his relationship with the girl. On 21/7/2026, the accused 26, the deceased boy went to the residence of the girl, and while he came back from her residence, the accused applicant, along with some other members of his family, allegedly abused, humiliated, intimidated, and physically assaulted the deceased boy. The deceased boy, it is alleged that the deceased boy came in a disturbed mind, and later on, the family of the deceased boy found that on the night of 22/7/2026, the deceased boy had committed suicide by hanging at the veranda of Valsala School. Though he was taken to the hospital, he was declared brought dead. It is alleged that due to the threatening and abused and intimidation by the family members, including the accused applicant, the deceased boy has committed suicide. In view of the aforesaid FIR, Bosista PS case number 296 under section 108 in bracket stroke 61 bracket 2 of BNS has been registered against the accused applicant. The learned counsel preparing for the accused applicant submits that there is no ingredients of any abetment of suicide in the instant case. And in fact, the boy and the girl were in love, were in deep love, and there was no evidence of any such treatment or intimidation as alleged in the FIR. He submits that in the accused applicant. He submits that the accused applicant has been implicated in the case only because he is the elder brother of the girl. Full stop. He prays for entering. He prays for entering PR's bail. The accused applicant in the instant case. Mr. K keep on information. The learned Mr. K wish the PPB on the other hand opposes the prayer of bail of the accused applicant. The PR's bail of the accused applicant. Full stop. After considering the interprets of the case and upon hearing the submissions made by the learned counsel appearing for the parties, this court has with the considered opinion that the accused applicant should be granted some interim protection. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Bokista PS case number 296, the accused applicant shall be granted, should be released on interim PR's bail on permission of a bail bond of rupees 30,000 with a security of like nature, with the satisfaction of the arresting authority, subject to the following conditions. Number one, the accused applicant shall appear before the investigating officer within 10 days from today. The accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. The accused applicant shall not tamper or hamper with the investigation by influencing any witnesses in whatsoever manner. Then the next paragraph, call for the CD. What is your submission, Mr. Vishu? And okay, and then the call for the CD, let the matter be fixed on
That's the second one.
7 September. The make it on the signals, not 7, make it on 2nd September.
The FIR is at page 11 minutes. In this case, the informant come victim, she is an advocate practicing at Silchar court matters. She is a habitual complainant. So she has filed a similar sort of case of allegation of 376 against 3 individuals. I am the third person.
Yes, Busha.
Page 26 is the judgment in which the first case was lodged and individual was acquitted.
Hmm?
Page 26.
Hmm.
Then she lodged the first complaint against one Jayed Ahmed Bolbhuya. That resulted in acquittal. And my lords will see at page 28 is the high
Page?
page 26. Page 21 is her statement as a PW1. What she has said. She had a PW1, so and so is the informant come as this case disposed in her deposition that in the year 2017, she had some affair with the accused so and so, but out of misunderstanding, she had filed an FIR. Ijhar. Now, my lords will come to page 31, my lords. This is the second individual against whom she has lodged the same complaint, same sets of facts. I read from the third paragraph. First is pursued the allegation made against the accused person, which is lodged by one lady named so and so, the daughter of so and so. The brief fact of the Azhar is that the informant stated that there were love affair between the informant and the accused made assurance to get married. The informant committed physical relationship with her. It is alleged that later on the accused stopped communication with the informant, who came to know
Okay, we are giving some interim protection to them.
grateful.
Heard Mr. So and so, learned counsel, appearing for the accused applicant, also heard Mr. T. Promotion, the application by APB for the state. This is an application under section 482 of BNSS 2023 for granting PRS bail to the accused applicant in connection with Sonai PS case number 79/2026 registered under section 464 1 3551 2 of BNS 2023. An FIR was lodged on an FIR was lodged on 3/8/2026 before the officer in charge Sonai police station by the informant alleging inter alia that accused person is known to the informant, not her, known to the informant, and since the informants the house of paternal home is near the house of the accused, who is a solar vendor contractor, the accused started interacting with her for certain affidavits and agreements, that the accused person started dropping her sometimes after her 4 hours in his car. It is alleged that on such occasion, taking advantage of her simplicity, he raped her against her will. On receipt of the FIR, police registered Sonai PS case number 79/2026 under the aforementioned section. The learned counsel appearing for the accused applicant submits that the accused submits that the informant is a person habitual of is a person habitual of filing complaint against different persons. So he submits that similar allegations were made against 2 other persons earlier on earlier occasions also, and in one of the cases the accused has already been acquitted. Other case, what is happening now?
Trial is going
In the other case also, trial is going on, and there are all the possibilities that the accused in that case will also be acquitted. In view of the aforesaid facts, and taking into account the character of the habit of the informant of filing frivolous FIRs. He prays that the accused applicant should be granted granted PRS bail in the instant case. The Mr. K. Boyster, learned APP on the other hand. On the other hand, what will be your submission? Sorry, I mean, submits that the allegations in the instant matter are serious, and therefore, without perusal of the case diary, the prayer of bail of the accused applicant should not be considered. Full stop. This court has heard the submissions made by the council appearing for the respective parties, and has also gone through the materials brought before this court. Materials brought before this court, especially the acquittal, especially the orders, especially the order dated 17/8/2019, passed in Sessions Case number 130 of 2018, passed by the Session Judge Kasa Silse, and having prima facie satisfied, this court directs that in the event of arrest of the accused applicant in connection with Sonai PS case number 79/2026, he shall be released on interim PRS bail on furnishing of a bail bond of ₹50,000 with a severity of like nature, subject to the condition to the satisfaction by arresting authority, subject to the condition that the within 10 days, then call for the CD, let the matter be fixed on. When? Okay, 9th of September.
In full minutes.
Item 10.
May I please your lordship? My lord, may I come to page number 16, my lord, FIR? Page number 16, my lord, FIR. My lord, the complainant hearing is the Hodo from Onnanno Oti Pispora Moria Kantha, President and Secretary, my lord. And the allegation is that, my lord, I am the former president and one other accused, my lord, that is Zeherul Ali, or the former secretary, my lord. That allegation is that I have the petitioner and the other accused have earned lakhs of rupees, my lord, by selling fake certificate, my lord, by using their name, paid, and registration number, my lord.
Yes, what is your case?
My lord, same case, my lord. I am Salam Ali, my lord. The certificate, my lord, is page number 18, my lord. Which is alleged as
So,
fake, my lord.
so allegation is that you have given fake certificates
Yes, my
by
lord.
taking money.
Because of that signature in this fake certificate, my lord. Page number 18, my lord.
Case number 18.
18, my lord.
Ah,
The bottom from the left corner, my lord. That is
Zeherul Ali.
not, my lord. Zeherul Ali already in the interim, my lord.
Hmm.
And I am, my lord, Salam Ali.
Hmm. Salam Ali, this is the signature.
Salam Ali, my lord. This is not the Salam Ali signature, my lord, as submitted before this honorable court, my lord. And I am a fourth grade employee of the GMCH, my lord. Because of this allegation, highly impacted on my service, my lord. So kindly, my lord, please allow me the interim at least, my lord, so that I could cooperate with the investigation, my lord. And in this respect, my lord, I have also filed an FIR against the Jehirul Ali, my lord, in my concerned police station, my lord.
Are you there in the committee? Are you there in the association?
No, my lord, presently I am not in the association.
When
In-
you were as a part of the association?
My lord,
You were part of the association earlier.
earlier, my lord.
When?
22, my lord.
Hmm?
In the year 22, my lord.
Hmm.
2022, 2nd of January, my lord, in my Ejahar, my lord, page number 21, my lord. May I read, my lord?
Hmm.
With due respect, it is informed that I, Muhammad Salam Ali, is the resident of village Malara, Islampur. I was serving as a president, and Muhammad Jehirul Ali, resident of Hajo Muslim Toti, as a secretary, my lord, till 2nd of January 2022 of the said association, my lord. On such date, a new committee was formed. It is come to know that Jehirul Ali has issuing identification certificate by issuing paid of the said association along with force my signature, my lord, on the identification certificate, my lord. When I come to know, my lord, it is immediately informed before the concerned police station, my lord. I am nowhere connected in this case, my lord, and I am strong apprehension of arrest, my lord. It is my humble prayer, my lord, at least interim may be allowed so that I could cooperate with the investigation, my lord.
Okay, heard, Mr.
Divya.
Give me the learned counsel. Appearing for the accused applicant also heard Mr. K.K. Bashir, learned appeal for the suit. There is an application under section 452 of BNS 6023, paying for granting fee arrest will in connection with Hajo PS case number 349/2026, registered under sections 3, bracket 5, comma 31318, bracket 4, comma 319, bracket 2, comma 336, bracket 3, comma 340, bracket 2 of BNS 2023. An FIR was lodged on 1/8. FIR was lodged on 19/7,
19/7, my lord,
19/7/2026,
and registered on 1 August, my lord.
26, which was registered on 1/8/2026 by one Shahjahan Ali, General Secretary of all Assam More Backward Moria in bracket M Association, before the officer in charge of the police station, alleging that the accused applicant, along with accused applicant who was the president, president of all Assam other more backward Moria in bracket M Association during the period during the period of from which time to which time?
My lord, the certificate was issued when I am.
No, where he were president when? Till
21.
from which date?
My lord,
No record.
yes, my lord.
He was
Uh,
earlier,
he was,
he was earlier president of the organization, served till 2/1/2022, and has been issuing fake certificates in the name of the association. Full stop. On the basis of the FIR, the police registered Hazo PS case number 349/2026 under the aforementioned sections. Full stop. The learned counsel, a penal accused applicant submits that he is no longer the president of the association, and he is not aware how the fake certificates have been issued in his name, as he is not a signatory of any of the fake certificates. He submits that his signature has been forged and used by one Jahirul Ali. He is also former secretary.
He is also
Former secretary. Former secretary of the association in the name of the association. Full stop. He submits that after the case was registered, the aforesaid Jahirul Ali, the former secretary has approached this court, and this court has already granted interim relief to the accused, to the aforesaid Jahirul Ali. He submits that he is an employee of he is a fourth grade employee. Fourth grade employee of GMCH and is willing to cooperate with the investigation. Cooperate with the investigation, and therefore he should be protected at this case. Full stop. The APP and Mr. K. Bashar and our hand opposes the prayer of bail. Prayer of is bail to the accused applicant. Taking into account the text of the case, this court will the considered opinion that the accused applicant should be granted some interim protection at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Hajo PS case number 349/2026, and the accused applicant shall be released on promising of a bail bond of rupees, shall be released on interim PR's bail and furnishing of bail bond of rupees 30,000, which is security of like a month, subject to the following conditions. 3 conditions you give, all for the CD, let the matter be fixed on
Not surprised.
let the matter be fixed on 9th September.
Nice.
9th September.
Please, your lordship. My lord, this is anticipatory bail application, my lord. There are 3 petitioners before your lordship. The petitioner number 1 is a retired teacher, my lord. And petitioner number 2 is the son of the petitioner number 1. And petitioner number 3 is the wife of the, my lord, petitioner number 1. So, my lord, before going to the FIR, my lord, I just give the brief background of this case, my lord. That the petitioner number 1, he is, my lord, youngest son, married to the complainant on, my lord, 15/12/2025. And that, my lord, your lordship will sign the page 23 is the, my lord, their marriage, my lord, photograph, my lord. So they are living very happily 1 month, my lord. After 1 month, my lord, the behavior of the, my lord, their complainant is, my lord, notice, my lord, she has some psychological problem. So she is creating some problem in the house, my lord, and throwing out the articles and etc. Then, my lord, finding no way out, that petitioner number 1's younger son, my lord, he filed a complaint before the, my lord, magistrate, my lord, which was earlier under section 107.
Petitioner number 1 is where?
Petitioner number 1 son is not before your lordship. The husband is not before your lordship. Now I'll come to that, my lord. His, my lord, younger son, my lord, who married that girl, my lord, complainant.
He filed a complaint.
He filed a complaint under earlier 107, my lord, CRPC, now 126 CRPC, my lord. And that was filed on, my lord, 2/6/2026. That these are the situation. So then, my lord, magistrate passed an order to make an inquiry. After making an inquiry, then a case has been registered. That is, my lord, page 16, my lord. This case has been registered after making an inquiry by the police station. So after knowing that, my lord, this present FIR has been
Where
lodged,
is the order?
my lord.
For registering the case.
My lord, that is page 16, my lord.
16 is the application.
No, 16 is the application, your lordship kindly see. At page
Application
18,
for,
my lord.
no, application for drawing proceedings under 126.
That is page 18, my lord.
That
Page-
is at 16.
No, that is page 18, my lord. No, that is after recording, my lord. I'll just
No, where is the order of the
yes, your lordship kindly see that straightway goes to page 18, my lord.
18.
18, my lord, forwarding to OC. Your lordship kindly see that forwarding to OC Lakhipur PS for inquiry and report. After getting report, that was registered on 3/8. File on, my lord, 2/6, but registered on 2/8. Your lordship kindly see left side column, my lord, in page 18, my lord. Number 268, dated 3/8/2026. So that is, my lord, complaint was registered, a complaint was filed, making an inquiry. After getting the inquiry report, this has been registered, my lord.
So 3-8, it has been registered.
registered, my 3-8.
Mm.
So 3-8, my lord, registered after getting inquiry report, my
Mm,
lord, all
mm,
that.
mm, mm.
Then, my lord, this FIR was lodged on 6-8, my lord. 6-8,
Mm.
stating, my lord, your lordship kindly say, now your lordship kindly do the FIR, my lord,
Mm.
page, my lord, 11.
11. Mm.
That is registered, my lord, filed on 6-8, my lord. Stating that, my lord, normal, my lord,
So
that
accused number 1 is not here.
no, not here, my lord. I'm just no 3, 4, and 5. 3 against the accused number
4.
2, 3, and 4. My lord, no rap, my lord. How rap can be
Second
attributed to them, my lord?
Fazle Karim Ahmed.
The section which was, my lord, mentioned in the FIR, that will not be attacked, my lord.
Okay. 1 second.
Now their complaint is that, my lord, that I have not made the registration marriage. Only the
Only the ritual, only the
my
customary
lord,
marriage.
only the social marriage was done. That is correct, my lord. They have mentioned, my lord, on 15/12 social marriage was done.
Mm.
Now, my lord, in the pretext of, my lord, we are sitting her. In the pretext of, my lord, registering marriage, my lord. Your lordship kindly say that is the language of the FIR, my lord. Now police has been registered a case under section, my lord, 64(1). So, my lord, I am not the husband. Maybe, my lord, maybe if it is, my lord, correct, maybe there may be a case against my lord husband, my lord, for yes, for the Prosar part. Although there is no section involved by any Prosar, my lord. 376, well, that is now 64(1). How in, my lord, for against 2, 3, and 4, my lord?
Third, Mr. Hmm?
Husband is not before.
Third, Mr. P.Z. Mahanta, Government Senior Counsel, assisted by so-and-so, learning counsel, appearing for the accused applicants, also. Third, Mr. K.K. Basu, Dynamic APP for the state. Reason application under section 484 of the MSS 2023, paying for granting PRS bill to the accused applicants in connection with Lakipur police station case number 131/2026 under section 83/64(1) of DNS. An FIR was lodged on 6/2026, alleging by the informant and before the appeal of Lakipur police station, alleging by the informant interviewer that the accused applicants, alleging that the accused persons, including the accused applicants, mm, with the promise of a registered marriage, took her to their house on 15/12/2025, and after that, the accused person number 1, namely Roshan Ali, has been having sexual relationship with the informant with the promise of having a registered marriage. It is alleged that whenever she asks for, she questions for a registered marriage, the accused number one, namely Roshan Ali, along with his family members, quarreled with her and physically abused her. Full stop. She alleged that she had been cheated and by such act, she has been cheated and accused number 1 had committed rape on her against her will. In terms of the aforesaid FIR, police registered Lakipur PS case number 131/2026. The learned next Mr. P.J. Mahanta, the senior counsel, submits that the accused applicant submits that the accused applicants are the father. One is father.
One is father,
Father.
two is brother,
Father and
two is brother-in-law,
father,
And-
brother-in-law, and
and mother-in-law.
and mother-in-law of the accused, of the informant, of the informant. No, no, no. First one is father of the accused number one. Second is brother-in-law of accused, the brother of accused number one.
Minus. No, but
Fazle Karim.
brother of the, son of the accused number one. Sorry,
that's
brother of the accused number one of the FIR name.
FIR name accused number one's
One's
brother,
brother,
and then
mother.
and mother of the accused number one. He submits that actually a social marriage was solemnized between accused number one and the informant. And after that, the informant started staying with the family of with their family. It is submitted that immediately after the marriage, the informant started making certain scenes in the family and quarreling with all the family members with certain pretexts, being compared with such situation, the accused number one, Rosen Al-Kabir had in fact filed a complaint before the executive magistrate Walpara on 3/8/2026, and after a preliminary inquiry, a case that is Local PS case number 131/2026 under section 83/64(1) of BNS has been registered against the informant. Full stop. He submits that after getting about after the informant came to know about the filing of the aforesaid complaint and registration of the Lakipur PS registration case number 131/2026, the informant had filed this the instant case against the accused applicants along with the accused number one, that is Mr. Rosen Al-Kabir. He submits that the instant FIR has been filed only to harass the accused applicant number one, as well as the accused number one, as well as the present accused applicants who were the family members of accused number one. Full stop. He submits that there is no allegation of commission on rape against the accused applicants in the FIR. He submits that taking into view the entire facts of the case, the accused applicant should be granted pre-arrest bail in the instant case. Full stop. This court has heard the submissions made by the council according to the respective parties, including the law of APP for the state. Full stop. Taking into account the entire facts of the case, this court is of the considered opinion that the accused applicant should be granted pre-arrest bail. Accordingly, it is directed that even the event of arrest of the accused applicants by the arresting authority in connection with Lakipur PS case number 131/2026, the accused applicants shall be released on pre-arrest bail on furnishing a bail bond of rupees 30,000 each to the severity of like amount to the satisfaction of the arresting authority, subject to the following conditions. Put these three conditions and they will appear within 10 days. No tampering, hampering in this division, then make themselves available before this thing. Then you write in terms of the aforesaid directions, the instant AV application is disposed of.
Develop.
Well,
May I please, Lordship, an application under section 482 of the BNN FFS, Lordship. FIR, Lordship, page 13, Lordship. May I read, Lordship?
Yes.
সন্মানপূর্বক বিনত নিবেদন এই যে জুয়া চারিমা দরি আসামি জনে মোক বিয়া কৰাৰ প্ৰলোভন দি ফুচলাই মাজেই তেওঁৰ ঘৰত মাতি নি জোৰ কৰি দৰ্শন কাৰ্য চলাই থাকে। মই আসামিজনক বিয়াৰ কথা ক'লে আসামিজনে কিছুদিনৰ ভিতৰতো বিয়া পাতি ল'ব বুলি কৈ থাকে আৰু আসামিজনে কৰা অপকৰ্মৰ কথা অইন মানুহক ক'বলৈ মানা কৰে বাবে ইমান দিনে মই অপকৰ্মৰ কথা গোপন ৰাখিছিলো। এনে সময়তে যোৱা ৬৬ তাৰিখে আবেলি অনুমান ৩টামান বজাত মোৰ ঘৰত কোনো মানুহ নথকাৰ সুযোগ বুজি আসামীজনে ঘৰৰ ভিতৰত প্ৰৱেশ কৰি মোৰ ইচ্ছাৰ বিৰুদ্ধে মোক দৰ্শন কৰে আৰু এই কাণ্ডৰ বিষয়ে অইন মানুহক ক'লে কথা বেয়া হ'ব বুলি ভাবুকি দি গুচি যায়। মীমাংসাৰ আশাত বছৰ দিয়াত পলম হ'ল।
Okay, we'll see the CD. I will see the CD. No interim protection at this stage.
Lordship, kindly page 3, para 4 and 5, Lordship.
Yes, what story you have written?
Lordship, if the FIR is assumed to true, Lordship, it will be case, Lordship, of consenting party, Lordship. Consenting party, Lordship.
Consenting
Can-
party. That we'll see what is there in the statement and CD.
Some protection may be given and call for CD, Lordship.
No. What is your name?
Midze Akhtar.
Huh?
Midze Akhtar.
Write her name and also KK Busul on the DP for a state. Reason application under so and so. You can write now. You can application under so and so. Then you write call for the CD. Let the material fixed on 27th. Give her early date. 27th date.
No, please, Your Lordship. Lordship, anticipated bail application, my lord. Your Lordship, the petitioners are the employees of a recovery agency, my lord. And against them, this FIR has been lost. Lordship will find the FIR, page 9, my lord. May I read, Lordship?
Yes.
With due regard, I would like to state that on 15/6/2026, morning hours at around 10:30 a.m., when I reached Natpusi Chowk, at the time, the member of the above mentioned MD associates, namely Kopil Roy, Tipu Das, and Topon Roy, and two other unknown persons obstructed my way and forcefully took away my motorcycle bearing registration number AS15U0753, which is registered in the name of my wife in lieu of default of finance amount. Thereafter, on 16/7/2026, I deposited an amount of rupees 5,000 on the phone pay and rupees 5,000 paid in cash to the accused, namely Kopil Roy. But the accused persons did not return the vehicle to me, and when I went to their office to take back my motorcycle, I was assaulted and they also snatched rupees 30,000, which I had taken in order to close my loan. So this is the allegation, my lord. What happened, my lord? This present informant, my lord, he obtained a loan from L&T Finance and he purchased a motorcycle in the name of his wife, my lord. Subsequently, he become defaulter, and after his account become NPA, my lord, this case was transferred to the recovery agency for recovery of the EMI, my lord. Accordingly, this is a fact, my lord. Accordingly, we went there, my lord, on behalf of MD Associates. We have asked him to pay the amount or to surrender the motorcycle to the finance company. Accordingly, he handed over the motorcycle, and that was taken to the finance company L&T, because we are not the custodian of the motorcycle, my lord.
You show me the where you have paid 30,000 rupees to L&T.
30,000 is the false allegation, my lord. So far, the 10,000 is concerned. Lordship will kindly come to page 16, my lord. Annexure 2. Immediately, that has been repaid when he lost this complaint, my lord. Annexure 2, page 16.
What is there?
By UPA, my lord. UPI transaction. The petitioner before your lordship, Kopil Roy, that amount has been given to him on behalf of the finance company, and he have immediately repaid that amount, my lord. This is the UPI transaction, my lord.
And you snatch the vehicle.
Lordship,
I mean, when you, it is not required to be taken the vehicle.
lordship, that is
See, NPA has happened, I understand. And he has paid the amount 10,000 rupees, 30,000 was due. Or what was the due amount?
lordship, 30,000.
30,000 was
30,000 was the due.
10,000 already paid.
On the next day, my lord,
The
16.
next day he paid.
Lordship.
Why have you handed over him the vehicle?
Lordship, vehicle is not with us. As
No.
soon as we take the vehicle, that is given to the finance company. It is in the custody of the finance company, my lord.
Where from where are you saying so?
Lordship, that is the instruction I have received, my lord. Because the recovery agent cannot keep the vehicle, my lord. It is the custody of the finance, because the financer is the actual owner of the vehicle. We cannot keep the vehicle, my lord.
But whether you can take away the vehicle like that?
Okay.
You are saying that like he has himself surrendered. Yeah, I mean, the allegation is not like that. FIR is totally different
And lordship, after 9 days, this FIR has been lost, my lord.
because you are not returning the vehicle properly, the bike. Okay, let him go. I mean, let him go. I mean, let him cooperate with the investigation.
Lordship,
There are two persons.
2 persons, my lord, Kopil Roy and my lord Manas Potim Das. He is not even FIR.
He is not FIR. This person also let him go on recovery agent and this things.
And this
But like-
Kopil Roy, my lord, he has returned the amount, my lord. So far, this, my lord, Annexure 2 is concerned.
You have not assaulted or this
No,
thing?
my lord. That part is totally false and fabricated, my lord. No assault, my lord.
In the affair also, there is no assault.
Allegation is not,
No snatching it, but not assault. Okay,
No,
like that. Hmm?
But name, but so far, my lord, the
No, no, they think themselves as big.
Lordship,
Above
the-
the law, yes.
so far, my lord, the first part is concerned, I do admit, my lord. But the next part of the FIR, my lord, regarding that, my lord, snatching of the amount and the assault, my lord. So far, my instruction is false and fabricated. allegation.
Your instructions is, okay, fine, like we are granting you the benefit of doubt at this stage. Third, Mr.
He does not.
He does, the learned counsel, appealing for the accused applicants, also heard Mr. P. Procedural and SPPB for the state. This is an application under section 482 of the MSS, weighing for granting 3 years bail to the accused applicants in connection with the previous case number 26/2026 under section 309 in bracket 4/115/126/111 of BMS 2023. An FIR was lost by one informant, namely Bilal Ali, before the officer in charge, Tihu Police Station, alleging that on 15/6/2026 at about 10:30 AM, the members of the MD Associates, namely Kapil Roy, number 1, number 2, Dipu Das, number 3, Tapan Roy, and other unknown persons obstructed his way and forcefully took away his motorcycle bearing registration number AS 15U0753, which was registered in his wife's name in a name due to the default of payment of EMI. It is also alleged that on 16/7/2026, he deposited amount of ₹5,000 on PhonePe and another amount of ₹5,000 in case to the accused person, namely Kapil Roy. But the accused person did not return the vehicle to him and when he went to take back the motorcycle motorcycle, he was assaulted and they also snatched ₹30,000 from him. In view of the aforesaid FIR, the police registered POPS case number 26/2026 under the aforementioned sections. The learned counsel appearing for the accused applicants submits that accused applicant number 1 has been named in the FIR. He is a person working with MD Associates and he has only taken the amount which was due from the informant, and the amount had already been transferred to the financial official. He submits that there was no snatching of amount ₹30,000 as alleged in the FIR. He further submits that the vehicle has, since that there was a default, the vehicle in terms of the policy of the financing company has been, has been duly returned by the informant rather than snatching the motorcycle. Full stop. He submits that accused applicant number 2 is not named in the affair. And taking not making name in the FIR, then he submits that in view of the aforesaid facts, the accused applicants should be granted PRS bail. Now this court has heard the submissions made by the counsel appearing to the respective parties, including the learned APP for the state. Having considered the entire facts of the case, this court will the considered opinion that the accused applicant should be granted PRS bail. At this case, accordingly, it is directed that in the event of arrest of the accused applicants by the arresting authority, by the investigating authority in connection with TVPS case number 26/2026, they shall be released on punishing of bail bond of rupees 20,000 each if like nature. The satisfaction of the arresting authority subject to the following conditions. Tinta condition within 10 days, cooperate with the investigation and make themselves available when required, and then shall not tamper and impose the investigation. Then next part, in terms of the aforesaid direction, the instant application is disposed of.
Obligation.
Just come back in 5 minutes.
If the matrimonial factor for the time being.
Who is appearing?
Mr. S.C. Vishwas, he is on legs in court number 1.
Pass off for time.
21.
CD hasn't come.
Yes, madam, but 30 days, madam, out of 60 days, madam. Mandatory period is 60 days, madam. Already complete 30 days, sorted, madam.
Mr. S. Das is present for the accused applicant, as well as Ms. S.H. Bora, the learned deputy for the state. CD is awaited. Did the matter be listed on
24 or 25, madam.
25?
Highly obliged.
22.
May I please alert? Matter will exempt for a day lordship for personal difficulty of engaged counsel ability of lordship. Matter may be exempt for a day lordship.
Why?
Some personal difficulty of engaged counsel.
CD is there.
Very may be retained lordship.
Okay. On the prayer of the learned counsel appearing for the accused applicant, let the matter be listed on 19th. 19th.
23.
ECR to answer. Hmm? Yeah, it is received. Mr. Bothakur. Okay, we'll pass it over for time.
After some time, not sure.
And
26.
CD is not there. CD not received. Let the matter be listed. On 27th? None appeared for the PTI phase of the when matter was called. CD is not available.
I'm sorry, number 23.
Wait for some.
After some time, my lord, the leading counsel, Mr. P.K. Muni is on legs, my lord.
Hmm?
Leading counsel, Mr. P.K. Muni is on legs, my lord. After some. Oblige.
28. dictate where to say that but it is not appealable. It is only
May-
telling them. May say one of the appealability may be possible.
Mr. So and so is
एक
present
अलग।
for the accused applicant. Mr. Ajay Barwal, and APP submits the CD is yet to be received. Let the matter be listed on. When, Mr. Barwal?
Part of September one. Yes. Part of September.
I've said about a lot of cases. Seventh September.
Oh, Lakshmi.
26.
May I be his lordship? Regular bail abuse, lordship.
Hmm?
Allegation is theft. Yes, 15 lordship.
Anything is there is of
Lordship, already co-accused Prohibitions is not allowed to go on bail by the longest sessions. Today is 40 days, lordship, behind the bar.
Today,
40 days.
40 days.
Allegation is theft, lordship, all. And all the stolen article already recovered. From one, Ahmad Ali, who has stolen the Warrant. Second one is considering nature of allegations, materials on record including the students. Also taking into consideration the period of detention of the accused and the advanced stage of the industrial business by it order dated 10 August 2026.
Okay, heard. Mr. Barwal, let him go. Heard, Mr.
A. Ahmed.
H. Ahmed, the learned counsel appearing for the accused applicant. Accused applicant also heard Mr. Ajay Barwal and APP for the state. Is an application under section 483 of BNSS 2023, claim for granting bail to the accused applicant. In connection with Goremari Peace case number 33/2026. 2026, an FIR was lodged on 9/7/2026 where the informant that the accused applicants have stolen his charger of e-rickshaw. It is seen that the learned counsel, I think the accused applicant submits that the accused applicant was registered on 8/7/2026 and seen that he is behind the bars. He is also submitted that the co-accused in the instant case, namely Sadiful Islam, has already been granted bail in the instant case. He submits that the accused applicant shall cooperate with the investigation, and therefore he prays that the accused applicant should be granted bail. Mr. Is there in the instant case is yet to be received? Mr. Boyle opposes that, my APP opposes the prayer of bail of the accused applicant. Having heard of the submissions made by the defense, the for the accused applicant, this court is of the considered opinion, the accused applicant should be granted bail. At this stage, taking into account his right of detention behind the bars. So accordingly, it is directed to the accused applicant should be released on bail on punishing of a daily bond of rupees 20,000 with facility of like nature. Like nature to the satisfaction of which court?
CGM Kamrup Amingaon.
To the satisfaction of the CGM?
Kamrup Amingaon.
Kamrup, CGM Kamrup. Subject to the conditions. The accused applicant shall cooperate with the investigation. Then we will make himself available when required by the investigating officer. Enough empowered and for the investigation. Then you write in terms of the opposite direction, the instant bail application is disposed of.
Deeply.
23. May I please also? Yes, such a case, my lord. This PCI received, my lord. Offense, my lord, involved is 64, my lord, in 90 days statutory period, my lord.
Hmm?
64 is involved, my section 64, my lord. 90 days is the statutory period, my lord. And today is my lord, 106 days, my lord. I am behind the bar, my lord.
106 days.
Yes, my lord.
Sorry,
Saturday file, my lord.
Hmm.
But in the law, file code, my bail application was rejected, my lord, on. So, but I am not only on my lord, the length of detention, my lord. I have seen the, my lord, the trial court record also, my lord.
What is the allegation? Hmm?
64, my lord, page 9, my lord. So, rape, my lord.
FIR.
Page 9, my lord. Incident is about 3426 and FIR is law about 2526, my lord. Four-person, my lord, including the expedition roaming here and there, my lord. And they consume alcohol, my lord. And thereafter this incident happened, my lord. What was the reference, sir? What was that? I've gone for the record also, and there is, admittedly, there is some allegation, my lord. As per the 183 statement, my lord. That's why I am only harping on the length of detention, my lord. The 20 years boy, my lord, he's behind the bar, last 106 days, my lord. And there is no chance of action being, my lord, also, my lord. As of now, the other witness provided the statement of the victim. That's why I am saying there is admittedly there is some allegation. That's why I'm harping on the length of detention.
Some allegations means
But today 106 days. That's why I'm saying I am on the length of detention. At 20 years boy.
Classified on 31/05/2026 on the basis of the materials and report of the submission methods and the pharmacy cases.
Yes.
And Dr. Baking on, which statement has been recorded, which is also corroborated. The either two witnesses seen for
Yes.
implications are given by the witnesses option and so far as portion retro conference is 34/2026 at about 7 p.m. And later examination is 2/5/2026. And in the medical examination, it was found that victim hand was not withdrawn. So that is also
Yes. No.
supporting option. Now the case is pending in the stage of appearance. 11/8/2026 was fixed for appearance. The charges are yet to be framed. If he gives option, he may file.
On this, obviously, but this charge would be the frame. I have
It's
no.
not the right time to grant him bail at least, because all the natural supporting evidence of questions to establish the fact that yes, committed to break under section 64 of the evidence. And they will be object at this stage. Charges are yet to be. Let the victim take some motion. There are also to consider.
But this is not a POCSO case, madam. The victim should have been examined, madam. See, as per the allegation, madam, all the madam.
at this stage, it will be difficult, Mr. Whatever.
Yes, madam. I know, madam. That's why I am harping on the length of
Victim
detention.
victim has not been also
Yes, madam.
examined.
Yes, madam.
Trial hasn't started.
Yes, madam.
Only charges are yet to be framed.
Yes, madam.
Charge sheet is filed. Allegations are quite serious.
Yes, madam.
At this stage, it will be difficult.
I know, madam. Maybe the outburst of the alcohol consumption.
Okay, heard Mr. S. Botagod, the learned counsel, appearing for the accused applicant, also heard Ms. S. H. Bora, the learned representative for the state. There is an application under section 483 of BLSS 2023, claim for granting bail to the accused applicant in connection with Hosai PS case number 91/2026 under section 64 BLS. An FIR was lodged on 22/5/2026, alleging that on 34/2026, the informant, while the informant and the accused applicant were together after consuming some beer, the accused applicant tried to forcefully sexually assault her. On the basis of the FIR, the police registered the PS case, Hojai PS case number 91/2026 under section 64 of BNS. And after completion of the investigation, police filed the charge sheet. Charge sheet when it was charge sheet filed?
31/5/20.
26 and presently the case is ready for framing charge, right?
Yes.
Framing charge. The learned counsel appearing for the accused applicant submits the accused applicant is a young boy and he's already behind the bars after his arrest and plea from 2026. He submits that since charge sheet has already been filed and taking into account his long detention behind the bars, the accused applicant should be enlarged and bailed. The player of the accused applicant has been is opposed by the learned APP for the stating that the statement of the victim is yet to be recorded before the trial court and charge is yet to be framed. Therefore, at this stage, the accused applicant should not be enlarged on bail. Taking into account that the accused that the scanned copy of the TCR has been received and the same is published. Living from time and curiosity, the accused applicant, whose court is not inclined to grant bail to the accused applicant at this stage. According to the instant, bail application is rejected.
At this is done.
At this stage.
Second query.
May I please allow? But this is a 483 application. I am behind the bar 164 days. From 7/3/26 minutes. Madam, what happened? In the social media, an advertisement was published that if you give me 1 lakh, I will give you double the amount. According to what I'm being tempted, madam, I came from Uttar Pradesh. I've sent a message that I'm coming with the money. Then I came to Gauhati. I contacted the messenger. He told me that you go to Kamakhya and pray there, I will hand over you back there. Accordingly, I went to Kamakhya. I prayed there and he handed over me the bag.
Your bail was earlier rejected
Yes,
by this court.
not rejected, my lord. Earlier it was filed, the charge sheet was filed during my bail petition. My Lord Justice Thakuria, madam, Lord has directed me go approach the trial court. Accordingly, I approached the trial court. Trial court has rejected at this stage. Then I have come again before your lordship. Now, my lord, the question is that the bag was given to me. I took the bag and stayed in the railway compartment, my lord, to go to my homestay. In the event, RPF police has brought me down from the compartment and seized that amount. But I had no mens rea. I have never given it to anybody, nor I utilized it for the purpose. And nowhere I have transacted that. And 50% of note is only one-sided, my lord, not full-sided. And I had no knowledge that it was all forged note, my lord. But I am one of the foolish man person being tempted falsely, my lord. I have come over here from Uttar Pradesh and paid 1 lakh original note, my lord. And he has returned with all this counterfeit note, my lord.
Where is there a WhatsApp message?
That I cannot, I have not given, my lord. What's the message?
Why then?
Because I have mentioned that because being tempted, my lord. I have mentioned that being tempted.
Tempted for what?
My lord, the petitioner came across a post in the social media platform Facebook relating to an alleged money exchange scheme, wherein it was represented that upon payment of certain amount, the payer would receive the substantially higher sum in return. It is submitted that at the relevant point of time, the petitioner was undergoing severe financial hardship and was under considerable pressure as the sole earning member of his family to provide for the needs of the welfare of the dependents. The petitioner had also traveled to Gauhati inter alia to seek the blessings of Ma Kamakhya in the hope of overcoming his financial difficulties. While in such circumstances, the petitioner came across the aforesaid representation and after making preliminary inquiries, establishing contact with the concerned individual, who was led believe that the offer was genuine, acting bona fide, and in good faith, the petitioner agreed to transfer rupees 1 lakh to his, upon his assurance of the petition and the said individual that he would return the receipt the sum of rupees 4,23,500 forged note, my lord. Para 2 of my application I have explained. Now, my lord, I have given some judgment before your lordship, my lord, which of our own High Court also, where, my lord, it is
Judgment on what?
regarding this type of cases, my lord. One is Shahrukh Ali and alias I have given it, my lord.
No, judgment on what? What facts exactly?
That in their judgment it said that after considering the material record, the court is of the concept opinion that merely sending a position, it is not a concert position, and he has not used it for any purpose, my lord. He has not exchanged for it, my lord. Uma Shankar, but the state of Chhattisgarh Supreme Court said that mens rea, knowing, having reason to believe some of the forged counterfeit essential to constitute the offense
under mens rea on the part of the accused must be proved by prosecution merely on the basis of evidence that the currency note given to PW by accused then a student of 18 years was fake, drawing a presumption that he had the requisite mens rea is not warranted under Section 4 of the Evidence Act. This is one. I have given it. Then, my lord, M. Mammootty versus State of Karnataka, the appellant has convicted the appeal under the Section 489B and 489C has been sentenced to arrive for 1 year and to arrive for 6 months. These currency notes have been to him by purchaser. He also said that he did not know that these currency notes were counterfeit, and he came to know of it for the first time when he was interrogated by police. There is no evidence of any witness to show that counterfeit notes were of such nature or description that a mere look of them would convince any person of average intelligence that it was a counterfeit note. We are not able to find out any inconsistency between the answer given by the accused in his statement under Section 342 before the session judge and before the committing court, especially on the point that appellant had the knowledge of reason to believe that notes were counterfeit. This is Supreme Court, my lord. Then, my lord, I am giving another judgment of Sundarlal. Settled position is that, para 10, counterfeit currency note not is enough to establish the guilt. Any individual in the usual course of business may come across fake currency note. Nothing has been on record to show that appellant had reason to believe that note used by him was counterfeit. Presumption of knowledge, mere possession can only be drawn if the notes were apparently counterfeit. In the present case, currency notes in the appellant's possession were not of such nature as could be recognized the counterfeit having looked at them. The prosecution is required to establish the circumstances clearly and establish that the appellants had the reason to believe that currency notes were in his possession were forged and fake. Then, my lord, 48 was also not followed, my lord. 48, my lord, that is our Shahrukh Ali versus the state of Assam, in said that 48, mere sending by electronic media will not be sufficient. WT message without stating therein the grounds arrest of the petitioner, the arresting authorities have not complied with the mandate of 48 of the BNSS. This is also very important, madam. My lord, any condition, if your lordship impose me, I'll review.
Now, what is the stage?
Now it is at the stage of evidence, madam. There is no evidence that I have been given it to anybody.
You have just received it. So
Received it, yes.
It takes time to give it to somebody else.
No, but there was no scope. Immediately police took take away from the
No, correct.
station.
The scope would
I
have,
was
the
only to my
scope would
home, my
have,
lord.
in your home you would have used it.
No, then, if I district, then the offense would have come up, my lord.
What do you do?
But I'm unemployed. Unemployed.
Anybody else has been arrested? No. On charge hearing. On charge hearing. Next date, charge frame,
For evidence.
posted for evidence. Which are the cases that you have referred? You have the case laws, give me the
Case law.
cases you have referred. Your submission is that there is no mens rea.
Mens rea and my lord, 48 also violated, 48. It was sent by WD message. Bihan Kumar is protected now. Without ground. Our High Court has held that I have given that
And
judgment.
how it will be given?
It was sent by WD.
Your wife is not there, your husband, your
My lord,
brother
yes,
is not
yes,
there.
They can send it, my lord, to the OC with the grounds.
Hmm.
Only intimation to the family. That was also not served.
See, this first case is like the M. Mammootty versus State of Karnataka.
Yes.
It doesn't help you at all because he purchased some amount, purchased some goods.
Yes, yes.
And so there is no, so this case is totally not applicable to your case. Mr. Biswas, like these are cases, these cases are not applicable to your case. In this case, some mangoes were purchased and like money was given to him and the money found to be fake currency and he was arrested. Then how this case is applicable to
Sir,
this
your
case?
lordship will appreciate one thing.
No.
That I had no knowledge. that it was
You
a-
hadn't, see, you come to Kamakya for blessing, getting 1 lakh of rupees, and you say that you are in financially hardship, you are unemployed. Can it be believable story?
My lord, I am a victim of such advertisement. That is your
Victim of
lordship.
such
Well, otherwise, why should I come from that way, from Uttar Pradesh to a
You have come for Kamakya's blessings, carrying 1 lakh of rupees.
No, because of that matter.
Correct.
Because there was an ad in that I will get double amounts this year. And my lord, 50% notes are one-sided, my lord, printed. I will face the trial, my lord. Kindly consider my detention period.
Here also cigarette purchasing. Mr. Biswas, rely on some cases which are relevant for your purpose. Don't rely on some cases which have no
Well, my
consequence.
main prayer is that
There is
I
no
had knowledge,
consequence
my
to
lord.
your
No,
cases.
I had no knowledge of this. And my lord, kindly consider the period of detention of 48 is there not followed, my lord.
Heard Mr. S.C. Biswas, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Boria. You want to show something from here? In TCA?
We take the fact.
Hmm.
There was understand my lord, and understood something I think in 180 of the BNS. Whereas punishment is my lord, up to life. Secondly, my lord, the effort is about my guardian, submitted regarding 48 notice with them. There's also been final trial for the year with my lord, that the case number 41.
Page number 41.
But it is a fact.
Last paragraph.
41.
41. Today, charges are same against the accused under 179 180 of BNSS. Apparently, huge quantity of fake Indian currency notes were recovered from accused, who has come from Uttar Pradesh to Gauhati to correctly verified there. So far as accused 48 of the BNSS is concerned, it is apparent from the case record that the notice under section 48 of the BNS was served upon the wife of the accused through WhatsApp. Record further reveals wife of the accused has confirmed over WhatsApp that they received the said notice. As apparently the notice under section 48 is duly served. It is relevant to mention here that the notice was the accused from Uttar Pradesh and as such it is not possible to serve.
Okay.
It is under the state.
Okay. Heard Mr. Then you read is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Sessions case number 118 of 2026 under section 61 in bracket 2, 318 bracket 4, 62, 178, 179, 180 of BNS 2023. Corresponding to GR in bracket PS case number 49/2026 under section 61. Same sections, on the same sections. You right. An FIR was filed on 6/3/2026 before the officer in charge Gauhati GRPS by ASI Jadov Chutia. Alleging inter alia that while conducting the checking of the luggages of the passengers at Kamakya railway station, along with other GRP personnel, they intercepted a person at platform number 1, Kamakya railway station, and on finding him suspicious, they checked his bag. It is alleged that during checking, they found 2 bundles of both side printed suspected fake Indian currency notes in rupees 500 denomination, and 8 bundles of one-sided printed suspected fake currency notes in rupees 500 denomination inside a black colored laptop bag from the possession of the accused person, who identified himself as Sandeep Kumar. On the basis of the FIR, police lodged GRPS case number 49/2026 under the aforementioned sections. The accused was arrested on 7/3/2026. 7/3/2026 arrested.
Yes.
26, and for last 162 days he is behind the bars. The accused, after completion of the investigation by the police filed the charge sheet.
Date of arrest 6/26.
Mm.
Date of arrest 6/26. 17
Yes, provision 70.
When was the charge sheet filed?
Charge
Charge
sheet
sheet?
filed, my lord. Charge sheet was filed. It is, charge sheet to. That no filed is now.
Police filed charge sheet on 31/3/2026. And presently the case is pending for evidence. Pending for evidence. Full stop. Any evidence? No evidence has been taken. No witnesses. Pending. Pending for evidence. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is an unemployed boy from UP who came to Kamakya Mandir for Kamakya Mandir for the blessings of the goddess. And during his visit, he came across one FB post which mentioned about return of huge amount of money in exchange of some investment. Being lured by such advertisement, he handed over rupees 1 lakh to one person, and that person had given him a bag containing certain currency notes. Certain currency notes. Full stop. He submits that he was totally unaware whether any fake currency was inside the bag. He thought the same to be genuine currency and had been paid to him in lieu of his payment of rupees 1 lakh. The learned senior counsel submits that since his knowledge about the fake currency is not there, there is no mens rea involved in the alleged offense as mentioned in the FIR. In view of the aforesaid, he submits that since prima facie there is no mens rea and offense committed, mens rea stroke offense committed by the accused applicant, where there is every possibility that the accused applicant shall be acquitted during the trial. Therefore, he submits that since the accused applicant is already behind the bars for 164 days, at this stage, the accused applicant should be released on bail. In support of his submission that there is no mens rea of the accused applicant, he has referred to the case of M. Mamutti versus State of Karnataka, reported in 1979 for SCC 723. Then you write Umashankar, then Umashankar versus State of Chhattisgarh, reported in 2001, 9 SCC 462, as well as the case of Sundarlal versus State Government of NCT, in bracket Criminal Appeal 451/2001, decided by the Honorable Delhi High Court on 16th May 2018, full stop. He has also, the learned counsel has also submitted that section 48 notice to the family members has not been complied, has not been issued in terms of the mandates of the BNSS, as well as the judicial pronouncements of the Honorable Supreme Court. The learned APP, Mr. R.J. Borua, learned APP, on the other hand, submits that the case is pending for evidence, and huge numbers of fake currency have been recovered from the conscious possession of the accused applicant. Full stop. Therefore, at this stage, the accused applicant should not be granted bail by this court. Full stop. This court has considered the materials available in the TCR, which has been submitted before this court, as well as heard the submissions of the counsel appearing for the respective parties. Full stop. Full stop. It is seen that the accused applicant was arrested with the bag containing fake currency notes. As far as the notes are concerned, that those are fake, that is, there is no dispute about that fact. Full stop. The case laws that have been submitted and referred to by the council are not applicable to the instant case, as in those cases, in all the three cases, the money received was in lieu of purchasing certain material by the person, and the same is without any knowledge of being the currency fake. Full stop. Full stop. But however, the instant case, the accused applicant had consciously delivered the ₹1 lakh, and in lieu of that, he has received the fake currencies. Full stop. Having found, then taking into consideration the fact that the trial has already begun, and the issue involved is circulation of fake currency, and also having found prima facie material, of his involvement in the prima facie material in the TCR, this court is not inclined to grant any bail for the accused applicant at this stage. Accordingly, the instant bail application is resolved.
I'll collect.
You face the trial. Let's see.
FIR is of a theft, my lord, so by unknown persons, page 13, my lord. And the petitioner before lordship, my lord, is actually, my lord, is a scrap dealer, my lord. He is a licensed scrap dealer. And I have an access trade license also from the panchayat. Page 13 is the FIR, my lord. On the account of suspicion, my lord, he was arrested, my lord. In fact, my lord, out of the 11 accused persons, 8 have already been granted bail, my lord. Behind the person, which is for the last 27 days. My lord. Basically, in the base for ground suspension, my lord, he was arrested. But his trade license, my lord, is there at page 41, my lord. It deals with, my lord, all this, my lord, scrap items and, my lord, also, my lord. And, my lord, unused brass and broken materials, my lord. On that ground, my lord, he was arrested. Yes, sir. In fact, he had surrendered. No? He had surrendered, my lord, and he was, his case is that, my lord, he was not aware that any of these materials were stolen because certain things were handed over.
These materials have been seized from his place.
He handed over these materials, my lord, because
Mhm.
he handed over these materials, my lord. Because
These are the stolen materials.
no, my lord, and lord, whatever was there, he handed over, my lord. But yes, my lord. I was not aware that, my lord, these are stolen materials, and because he's a scrap seller, my lord, he kept this on bona fide, my lord, belief, my lord. And he's cooperating with the investigation, my lord. But 3 have been granted by this honorable court, my lord, and others, my lord, by the honorable, my lord, session judgment.
What about this case, other one?
Other one, my lord, he is suspected to be involved in the theft, my lord. He is also cooperating with the investigation, my lord. He has been arrested basically on this basically on the basis of suspicion, my lord. Nothing was found from his possession, my lord, and he's just been arrested on the basis of suspicion, my lord, that he was also involved.
If there is sufficient vehicles collected by the in this case, one music collector and the says into the account, I can remember in the production. They are all involved. So they show this property to the other accused person. And there's a melody no case, one of the receiver, and also will party of the children performance. And progress this my lord, what's the promise to I can put it. So that is some other issues, but it has to be the investigation is pending.
There is another person called Nobojit Lohkar. Who is Nobojit Lohkar?
Navakumar Locker is you.
Yes, ma'am. I'm Navakumar. There's another person called Nobojit. No? Another person is Nobojit who is absconding.
How many people are involved together? Altogether, how many people are there?
11, I think, if I'm not wrong, 11. 3 have been granted by bail by this honorable court. 5. Oh, 5 by this honorable court and 3 by the learned session judge.
Their statements have also been recorded, my lord, so therefore, my lord. Second given in 29 days. Second person is behind bars for the last 29 days. First one is for 27 days. The first case also, admittedly, 35 notice was not issued, my lord. Is reflected in page 23 of the melody. It's a part of the melody. Forwarding report.
Heard Mr. M. Doctor, the learned counsel, and senior counsel assisted by students of appearing for the accused applicant. Also heard Mr. R.J. Burwa, the learned advocate for the state. There is an application under section 483 of BNSS 2023, weighing for granting bail to the accused applicant in connection with Secretary Police case number 69/2026 under section 305, 331 in the code. Stock 317 of BNS 2023. An FIR was lodged by one Vision Sharma on 17/7/2026 before the Sattavali police station, raising that on the intervening night of 15/7/2026 and 16/7/2026, some unknown miscreants broke the lock of the grill of veranda of his house in absence of family members. Family members that sometime that after entering the house, the miscreants has committed that whereby 12 pairs of utensils from about 20 pieces of brass metal and an inverter machine, believed that it is 15,000 were stolen. On receipt of the FIR, police registered Sattavali police station case number 61/2026. The learned counsel, the learned senior counsel appearing for the accused applicant submits that the accused applicant was arrested on 27/2026 at 3:30 p.m. in connection with the case. He submits that the accused applicant is a licensed scrap dealer, and he was totally unaware about the stolen properties. He submits that he used to buy scrap materials, including damaged utensils from various persons on bona fide belief, and he had been dealing with this business for quite some time. He submits that after coming to know about the FIR, registration of the FIR, he has surrendered. Here you surrendered yourself.
My lord.
He has you surrendered or you were arrested?
Surrendered, my lord. It's there.
He surrendered. He surrendered on 27/2026 himself, and he was thereafter and thereafter his statements were recorded and he was remanded to police custody. He submits that he has already spent more than 27 days behind the bars. He further submits that that after investigation, police have arrested. The investigating authority had arrested about 11 accused persons, and out of them 8 they have been already granted bail by Honorable High Court, and the additional session judge, Honorable High Court and additional session judge in bracket FTC about it. He submits that taking into account the fact that the accused applicant has already spent more than 27 days and the investigation has substantially progressed. Further detention of the accused applicants may not be required in the instant case, and therefore he prays for bail of the accused applicant at this stage. CD in the instant case has been produced and the same is produced. On the other hand, Mr. R.J. Burwandal APP opposes the prayer of bail by submitting that there are sufficient incriminating materials against the accused applicant. He submits that the investigation is still going on, and the stolen article and though certain stolen articles have been recovered, all of them have not been recovered as yet. Therefore, he prays that the instant bail application should be rejected. This court, after due consideration of the materials brought before this court in the CD, as well as taking into account of the fact that stolen articles, most of the stolen articles have already been recovered, and the accused applicant has already spent 27 days behind the bars, is of the considered opinion that the accused applicant should be granted bail at this case. Accordingly, it is directed that the accused applicant shall be released from bail on furnishing of a bail bond of 30,000 with a severity of like nature, with the satisfaction of which court? Which court?
The
Satisfaction of
session judge, sorry, CJM, Borpeta.
Borpeta.
CJM Borpeta.
Satisfaction of the CGM Borpeta. Borpeta. Subject to the following conditions. If these 3 conditions, in terms of the aforesaid direction, the instant bail application is disposed of. The next one is right. This is an anticipatory bail application. You have the hard so and so. Then you write this is an application. Then facts will be same. The facts will be same. FIR will be same. Then you write.
No recovery, no? No recovery was made from him. He has been also arrested under suspicion. Para 17 I've said. Para 17 I've said, nothing has been recovered from him.
Nothing has been recovered.
Recovered from my position.
But isn't a very okay.
He's also one of the member of the head team.
Right.
Para 17.
They immediately sold the article to different people, and then when they share their money.
So you were inside the jail for how many days?
29 days.
29 days. The learned counsel appealing for the accused applicant submits that that on the basis of the statement of the co-accused, the accused applicant who was arrested by police, however, no stolen articles have been recovered from him. He submits that since the accused applicant has already spent more than 29 days behind the bars and the stolen articles have been recovered by police from another co-accused, the detention of the further detention of the accused applicant may not be required in the instant case. And then CD is received and film is produced. Mr. Arjay Burwal and APP on the other hand opposes the fear of bail of the accused applicant, submitting that on receipt of the information about filing of the FIR, the accused applicant has sold the stolen articles to some other persons. Full stop. He submits that the investigation is still going on and therefore the bail should not be granted to the accused applicant. After consideration of the submissions made by the learned counsel appearing for the respective parties, this court of the considered opinion that the accused applicant should be granted bail at this stage accordingly. Then same order it was, 20,000 and bail is disposed of.
Diploma.
25.
My lord, in this case, what happened, my lord? He is a pharmacist, my lord, qualified for B Pharma. He have got a pharmacy, my lord. And my lord, this informant has visited his house. He is this stethoscope, pad, but there was no doctor written in the pad. It was only B Pharma. And he has got the other rural certificates of the all India basis, my lord. He was selling medicine, my lord. He has never prescribed any medicine, but he has been.
Allegations are, I mean, allegations against him is that he is prescribing.
The FIR is valid that he is posing himself as a doctor. But they are using the stethoscope. They can do it. They can give a slip also that bring this medicine. He is a qualified pharmacist.
Let us CD come because
CD was called for. Your lordship has picked it today, but the message has gone to the police on 15/25/8. Is not it? 25/8. I have seen it.
25/8.
8.
25/8 means
of this month.
Today is
your lordship has picked.
How can it be
today.
25/8?
We have inquired in the police station.
Today is what? Today?
Today is 17.
17. 17/8.
8.
And 25/8, how it will go?
Because we have message has gone from here, it is 25/8.
25/8 or 25/7?
25/8, my lord. Next, in this month of. Next date is fixed 25/8. It was called for 25/8.
No, I'm not getting what you're saying. The case is fixed today.
Yes.
Then?
Your lordship has
The message has gone that CD should.
fixing 25/8.
Okay, when you communicate to him, when will you fix?
25/8, let it come.
25/8. 25/8, not much days are there.
It will come, my lord.
25/8 will fix.
But my lord, I have not committed any offense. Meanwhile, already 23
Let
days
us
of
see
behind the bar.
consideration. I mean, this fake doctors are. I mean,
I admit, take doctor, but
mushrooming everywhere.
I have never posed as a doctor. In my pharmacy, there is a stethoscope. My pad is there without showing my name as doctor.
So we'll see what is there. CD is awaited. Mr. SC Biswas is present for the accused applicant. Let the matter be fixed on 25/8. 25/8 to
27.
Was called for
Is there is come?
the informant is the tenant of the petitioner. The my lord will find the FIR at page 10. Page 10, my lord. Accused number 1 is before your lordship. If I may read it, man. All the allegations are against accused number 2 and accused number 3.
All allegations against?
2 and 3, my lord. Well, from the FIR, my lord, it is apparent, my lord. FIR, my lord, you find page 10.
You are behind the bars for how many days?
68 days, man.
Mr. Borua, anything incriminating, anything measure?
That was in, yes, that was done by accused number 2, man. FIR says, well, accused,
His allegation is against he pushed.
he pushed.
When the victim has also implicated this person.
Some involvement is there, let him go. Heard Mr. P.K. Munir, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwal, and the APB for the state, is an application under section 483 of BNSS, you write it, huh? And then an FIR was lodged on 9/6/2026 by the informant, namely Abdul Kalam, alleging that on 9/6/2026 in the morning at around 11 AM when he was working in the garden, the FIR named accused persons started obstructing them from cleaning the garden. It is that when he asked the accused number 1 the reason for such obstruction, instead of answering, he became aggressive and pushed him to the ground and assaulted him. It is alleged that when his wife came forward to rescue him, the other 2 accused persons tore her clothes and beaten her, and the accused number 2 attacked him with a dowel on his face and thereby breaking 2 teeth in the upper jaw and 4 teeth of the lower jaw were loosened. On receipt of the FIR, the police registered Khatkhoti police station case number 74/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant has not committed any injury on the informant. He submits that he is already behind bars for last 68 days, and taking into account his long detention, he should be released on bail. A CD in the instant case has been produced, and the same is produced. The learned Mr. R.J. Boror and an APP on the other hand opposes the bail application. Taking into account the interfacts of the case, this court can interfacts of the case, and also the fact that the accused applicant has already spent 68 days behind the bars, it is directed that the accused applicant shall be released on bail immediately on punishing the bail bond or of rupees 30,000 with a security of life nature to the satisfaction of
SDGM
Bukazan, subject to the following conditions, to those 3 conditions. In terms of the aforesaid direction, the instant bail application is disposed of.
Deeply obliged.
29.
My lord, there is an interim order. I'm appeared and recorded statement. So many times they call the CD, my lord. Your lordship also 2 occasions, your lordship.
So many times, no.
But till today, but as per information, my lord, yesterday I am informed by the client, my lord, FIR has been committed, my lord, but I cannot say, my lord, but FIR.
Next week he is asking for 1 day.
Yes.
Okay, Mr. N. Bora is present for the accused applicant. Mr. R.J. Borua is land APP, is present for the state. CD is yet to be received. Let the matter be listed on 26th.
26th. My lord. Interim order may be continued.
Interim order so passed earlier, shall continue till the next date of listing.
Yeah, please, Your Lordship. Lordship.
Before that, heard Mr. A.K. Azad, the learned counsel appearing for the accused applicant, also heard Mr. R.J.
Lordship,
Borwal
please consider.
This is an application under section 42 of BNSS, praying for granting PRS bail to the accused applicant in connection with Kajal Gaon. Okay, write this, that application under so and so. The learned Mr. R.J. Borwal and APP submits that charge sheet in the instant case has already been filed. Why charge sheet number?
54 of the 2026, dated 15/6/2020.
26. In view of the aforesaid submission, the Lord Council, appearing for the accused applicant, submits that liberty should be granted to him to appear before the jurisdictional court. Jurisdictional court, full stop. Taking into account the aforesaid facts, it is directed, the instant AB application is disposed of with a direction to the accused applicant to appear before the jurisdiction court within a period of 15 days from today until that date. The interim PRS bail granted to him by the order
Kindly call for the TCR.
2026 shall stand extended. Shall stand extended. You go and appear 15 days protection I have given you. Interim order is there, so you go and 15 days, within 15 days you appear there.
Gotcha.
31. Interim. Equal to reject.
Okay.
He is cooperating with the investigating agency, my lord. He has appeared before the IO, my lord.
Yeah.
So let him bring next week. Heard Mr. I.S. Sakya, well-elected counsel, appearing for the accused applicant, also Mr. B. Sharma, well-elected appeals for the state. Mr. B. Sharma appeals a week's time to procure the updated CD in the instant case. This prayer is allowed, let them be listed on 26 hours. Second September. Okay, second September, interim order so passed earlier, I'll continue to the next day.
But
32. That's it for me to close.
You go and appear.
Interim order is there.
Okay. Right, same thing, heard Mr.
Yes, Ahmed.
So and so, then is an application. Okay, then he said the subsidy is submitted by the
44. Dated 8/7/26.
26. Then same thing, right? 15 days. Will appear.
Like
33. But it's not in the interim. Even properly received.
She did not receive.
It is not received.
Okay, we'll give another date. Mr. I alum.
T Shekman.
Huh?
T Shekman.
The P6 relevant counsel is speaking for the accused applicant. Mr. B. Sharma and APP for the state. The red light CD is awaited. Let the matter be listed on let it be on 10th of September.
Petition is an interim.
Interim order so passed earlier, shall continue.
Highly obliged.
34. Tacit submitted.
I think the petitioner appeared before the IO in terms of interim,
So you go and appear there.
my lord.
Heard Mr. So and so, the same order, huh? Charge sheet number and date it.
March 26. Dated 20/06.
15 days you appear.
My lord. Obligement.
35.
Okay,
That's it, gonna be on 27.
27 will be too, 20, it will take some time. Heard MS,
See, second.
so and so, and Mr. B. Sharma. CD is awaited. Then let the matter be listed on 10 September.
10th September.
10 September, in the meantime, then interim order so passed earlier, shall continue.
Interim, maybe continue. Yes.
36. CD received also.
May I please, your lordship? FI page number.
Medical report, some medical report.
This persons injured. One person was injured. Penetrating knee on the internal aspect of abdomen. So the screwdriver was inserted into stomach function. And also might be best fracture in anterior aspect of left knee. The also knee was also broken. In the respect for one victim and another was He also suffered injury, also physical, also laceration and all also. So this one is previous.
Lordship, father and mother of the petition number already granted bail by the learned additional session judge.
Father and mother are different.
Father, male accused.
Huh? Main accused,
Lordship.
father, mother, house, let's see.
They are the son.
Huh?
Petitioner number one, son of the main accused, and 1 and 2.
Hmm. Let us
Already
see what is the FIR.
Look. Already 12 witnesses examined, Lordship.
Hmm?
12
12 witnesses examined?
Lordship.
Trial is going on over
No,
before the police.
Lordship.
So what is the material there? We'll have to see.
FIR page number 10, Lordship.
Page number?
10,
10.
10, Lordship. Type copy. Vernacular is 16.
I witness, even the injured person. In the medical report. Like my Lordship, the eye witness. Also the medical.
Serious allegations, Mr.
Lordship.
Bora.
Lordship.
Created ruckus.
Attached, Lordship.
3 days, Bhavna, and they create all this thing.
The Bhagavad was going on.
Difficult.
Firstly, quarrel between the father and mother of the petitioner number 1.
Serious allegations. You'll have to, I mean, you participate, you go, but at this stage, bail will be difficult.
Lordship.
Heard Mr. K. Bora, the learned counsel appearing for the accused applicant. Accused applicants also heard Mr. B. Sharma, learned KTP for the state. Reason application under so and so. Then you write, and a FIR was lodged. FIR was lodged by one Sivani Hazarika. before the officer in charge, Pulipur Police Station in 21/6/2026, alleging that Akhanda, while Akhanda Bhagavad Path was going on for 3 days, comma, on 26/2026 at about 12 a.m. during the aforesaid program, Sri Jayanta Hazarika, son of Yukeswar Hazarika, and his son Akash Hazarika, and one assist Hazarika, allegedly committed some ruckus and disturbance of the program by uttering filthy language and damaging chairs. Full stop. It is alleged that when her husband being the president of the organizing committee, tried to intervene and find out what had happened, the accused persons, namely Jayanta Hazarika, Akash Hazarika, Ashish Hazarika, and Rinku Hazarika, assaulted her husband by iron rod with the intention of causing grievous harm. Full stop. It is alleged that during the incident, though the accused applicant somehow, though the husband of the informant somehow managed to save his life, but he is grievously injured. Full stop. On receipt of the FIR, police registered Pulipur PS case number 57/2026 under the aforementioned sections. The learned counsel, according to the accused applicant, submits that the two of the accused applicants have already been granted, and the two of the accused persons, the instant accused applicants are young boys of 21 years age, and taking into account their age, they should be granted pre-arrest bail. Full stop. CD in the instant case has been received and the same is produced. The learned with Mr. B. Sharma, learned APP, opposes the pre-arrest bail application of the accused applicants, stating that grievous injuries have been caused on the husband of the informant. Therefore, he opposes the bail application. Taking into the CD in the instant case has been produced, and taking into account the entire facts of the case and having found aforesaid materials against the accused applicants, this court is not inclined to grant any pre-arrest bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected. CD to be returned.
Master.
47. Here, cases registered under 150 subsection P, section 65(1).
Section 65(1), yes.
In section 65(1), also takes up DNSS questions.
65(1),
Yes.
65(1), 127(2),
Yes.
and 4 POCSO. But other sections are there.
Here. Take up DNSS.
BNSS.
Yes.
Yes.
482, section 482.
Hmm. 482.
482 subsection 2. Nothing in this settlement will apply to any case including the arrest of any person or of having committed an offence under 65 and subsection 2 of 70.
Nothing in this section shall apply to any case involving arrest of any person. Section 65 and subsection 2 of section 17. But it is, I mean, 65, it says that there are two things. One is like 16 years and 12 years. For 16 years, 12 years, all minors. It keeps on happening. POXO is there, Special Act is there. Now, since Special Act is there, whether that will take away the court's jurisdiction. 65.
One comes to thinking, provided lordship, the materials integrate. And if here also will have to use a statement, is the only accused person. POXO part is also there.
The POXO part is there. I mean, so you have any case laws on this? Hmm?
Or granted bail, where will chip the equation in a 180 is not before them. Not against that, then bail has been granted. But anticipatory bail with the main accusation is the implicated one, and 65 1 has been inserted. That is also, this is not consistent.
You understand what he's saying, you understanding?
Lordship, there is a overriding things has been done and FIR was registered prior to the incident, Lordship. FIR was registered prior to the incident, according to 180. Yes. The statement of the victim.
How? Or she was kidnapped.
She was
Yeah, now he's saying that like if section 65 is involved, then anticipatory bail is not, I mean, anticipatory bail will not lie. There's a bar by this section. But 72, is that? 72 is not involved in this. In this case, it is not. I'll have to reject it.
Can they allow this bail petition, Lordship?
Why should I? You tell me why should I allow it?
Under any terms and condition, Lordship?
Sir, that is different thing. Have statute bars it? How can I allow this? I'll pass the order. I'll just look into other things, sir. I'll pass the order.
Hello, Lord.
CD is with me.
CD is available. The Lordship will find the FIR at page 14, ma'am.
Yes.
Now, in this case, as far as the FIR goes, FIR says that the informant has paid me 15 lakh rupees. I was acting as a middleman. Well, out of this part, my lord, one part is admitted, my lord. This 8,80,000 rupees was indeed paid. There is no dispute about that, but this, we have put it in our petition also, my lord.
No, that is that hardly matters. You tell me like why, I mean.
Yes, but in this case, this amount which was paid to us, that amount was paid not pertaining to this transaction. This amount was paid because we had sold him Agarwood's the other wood, the wood, my lord. We had sold him that wood. For that, he had paid us this amount. Regarding this particular allegation, here the allegation is that I was only acting as a middleman, my lord, to facilitate the sale between the informant and another person. That sale did not occur, my lord. Now, what the informant is doing is that this another 9 lakh rupees, which he paid me to a different transaction, my lord. Now, he has brought this into this FIR. In any case, if the informant has any grievance regarding this money, the informant actually tries to project that he has actually paid me 15 lakh rupees, my lord. This is something which can be tackled up in a civil court, my lord.
No,
For
this
recovery
is not a civil court. This is not a civil
recovery
court.
of money, my lord. Only on that recovery.
No,
money.
no civil court, no civil.
Now, as far as the offense of cheating is concerned, my lord, cheating and
The
dishonor-
purely from the FIR, it's a purely case of cheating. You convince me that it's not a
Yes,
cheating.
well, even otherwise, and on the merit of the case,
Hmm.
these are offences, my lord, where the punishment is up to 7 years. my
Hmm.
lord. So the law mandates that the IO ought to have issued a 35(3) notice to me.
Hmm.
Had the IO issued a 35(3) notice to me,
Hmm.
and I had not cooperated during the investigation,
Hmm.
then under 35(6), the IO could have
Hmm.
arrested me, my lord.
Hmm.
So even without going into the merit of the case, so the default position is that notice to be issued to me and I cooperate. If I don't cooperate, then they arrest me. So I'm even today, I'm ready and willing to cooperate. I'm ready and willing to show.
You go and
Yes.
surrender then.
No, but in that case, because
You go and surrender. And they will issue a 35(3) notice.
35(3) notice.
35(3) notice, they'll issue a notice to you. You issue a 35(3) notice if required. You go and you go and
issue notice, my lord, I'm ready and willing to appear. my lord.
But I'm not going to give you any protection in this case. You go and appear.
Because my lord, if your lordship will see this aspect, my lord.
What is there? At this stage, it will be difficult, Mr. Nawaz.
Well, may I submit one thing, my lord? In the facts of this case, my lord, custodial interrogation may not be
No, it will be
I'm
required.
ready and willing to cooperate otherwise.
This court thinks that custodial detention will be required.
No, to be my submission, madam. So your lordship will decide that part, madam. But otherwise, had they issued this notice, madam, I would have appeared and cooperated. Now only appeared.
They may issue it, I don't know. I mean, it's up to them. They may issue tomorrow also. But why should I protect you? Heard Mr. S. Nawaz, the learned counsel, appearing for the accused applicant, also heard Ms. S.H. Bora, the learned APP for the state. An FIR was lodged on 31/5/2026. Alleging that the accused applicant Amir Hussain called the informant and his friend, namely Abdul Ghafoor Laskar, for a business negotiation. Semicolon. It is alleged that the accused applicant represented himself as a middleman, and he introduced one person who is supposedly the owner of a rubber tree garden. A tree garden. It is alleged that the accused applicant told the informant that he will arrange a lease of approximately 15,000 rubber trees for a period of 1 year at the rate of 100 per tree. It is alleged that total amount proposed for the whole lease was, or lease came to rupees 50 lakhs. The accused applicant requested the informant to pay 15,000 as advance immediately. Accordingly, the informant paid an amount of rupees 8,80,000 through online banking and rupees 6,12,000 in cash. It is alleged that later on, upon verification, it was found that the rubber plantation rubber plantation mentioned by the accused applicant does not exist in the name of the person introduced as the owner. Also, the accused applicant, it is alleged that accused applicant could not provide any documents regarding the ownership of the rubber plantation by the person introduced, as well as they failed to return the money to the informant. In view of the aforesaid FIR, the Murad Jhar PS case number 127/2026 is registered under the aforementioned sections against the accused applicant. The learned counsel appearing to the accused applicant submits that section 35(3) notice is yet to be issued, issued to the accused applicant. And the accused applicant, he submits that if such notice is served upon him, he will cooperate with the investigation. He will appear before the IO and cooperate with the investigation. Accordingly, he submits that at this stage the accused applicant should be granted PRS bail. Case diary in the instant case has been received, and the same is produced. Also heard the submissions made by the learned APP on perusal of the case diary and on consideration of the submission made by the counsel attending to the respective parties. This court is not inclined to grant any anticipatory bail to the accused applicant at this stage. Accordingly, the same is rejected. CD to be returned. You appear 35(3) is they will issue. Okay, CD is yet to be received. Interim order so passed earlier shall continue till the next date of listing. Let the matter be listed on 2nd of September.
May I please, my lordship? So in this case, I have been informed that charge sheet have been filed, my lordship. So I'm praying for withdrawn by annexing the charge sheet with the new filing fresh one. Lordship, in this case, I have been informed that charge sheet have been filed, my lordship. So I'm praying for a withdrawn such that I can file a fresh one, annexing the charge sheet, my lordship. If the lordship permit me, my lordship. After I have filed,
Charge sheet file, you go there, appear. What is there to you? What do you will file here? Bail
charge sheet
application you will
number
file.
is not there.
You'll file bail application or what?
Yes, my lordship.
Huh?
Yes, my lordship.
Bail application you can always file. Okay, under prayer of the learned counsel, Mr. R. Amin, for withdrawal of the instant AB application. The instant AB application is disposed of as dismissed on withdrawal.
41. Not available.
Okay, Mr. S. Nawaz is present for the accused applicant, as well as S.H. Bora, the land APP. Case diary is yet to be received. Let the matter be listed on when? 2nd of September. Second lot of matters have been fixed already.
But can it be on 27th, madam?
27th of
27th of August. Leave level. 42.
May I
Yes,
please,
madam.
Lordship? FIR is at page 10, Lordship.
Lordship, actual fact of the case is that on
Now you
8/9,
give me the facts. You don't have to give me the actual facts.
Lordship, on 8/9/2020,
Hmm.
Lordship, the accused purchased the one motorcycle
Hmm.
on good faith from one Jahangir Alam
Hmm.
for rupees 50,000.
Hmm.
Lordship, agreement to Annexer 2 is the agreement
Hmm.
at page 15.
One second.
Lordship, and after few months of purchasing, the accused was facing financial hardship, and therefore he proposed to sell the said vehicle, and accordingly on 10/12/2020, the informant purchased the said motorcycle from the petitioner. Lordship, petitioner had no knowledge that the said motorcycle was stolen one. He purchased the alleged vehicle from Jahangir Alam on good faith.
One
And-
second. Just a minute. Huh? Just a minute.
Lordship.
He has himself given this, it seems. This FIR has been filed by him only. Hmm. The complainant is who? Complainant is Aminur Khan. He filed against the person Monwar Hussain. Monwar Hussain is the person who sold him the vehicle.
Yes.
And now before this court, this person, Monwar Hussain. So what are you reading?
Lordship,
You are saying that you do not know. You do not know what?
Lordship, I have purchased the vehicle from one Jahangir Alam.
You have
Lord-
purchased from one Jahangir.
Jahangir Alam, Lordship.
You are Monwar Hussain.
Yes,
You
Lordship.
have purchased from Jahangir Alam.
Yes, Lordship.
Jahangir Alam did not give you any document.
Lordship, no, he did not give any
But
document.
you have manipulated the registration certificate and sold it to this Aminur Khan. How?
Lordship, informant has keeping the motorcycle under his possession for long period of more than 5 years.
What is there in the CV?
So police document out regarding the agreement between one Jahangir Alam and the present petitioner that he has purchased a safe vehicle from Jahangir Alam. So that's
That is there.
that agreement is not there at this
Hmm.
point. It's easily structured. Concerned violation is from the petition, along with one certificate of registration by petition number so. The CSS number is matching, so and so. The financial institution is one Bindu Das. One Bindu Das.
Madam, it will be difficult at this stage. Let the investigation be completed. Third MS so and so. What is your name?
Miss M. Das,
M. Das.
Lordship.
It will be difficult at this stage, madam. Third MS M. Das, the learned counsel appearing for the accused applicant, also heard MS SH Bora and APP for the state. Is in application under section 482 of BNSS 2023. Paying for granting pre-arrest bail to the accused applicant in connection with Pocketguns PS case number 50/2026 under section 336 in bracket 3 /303 bracket 2 /317 bracket 2 of BNS 2023. When an FIR was lodged, FIR was lodged on 21/5/2026 before the Pocketguns police station alleging that one motorcycle being registered number AS01EE46482 was purchased by the informant from the accused applicant about 5 months ago. Later on, it was found that the accused applicant had manipulated the registration certificate and sold a stolen motorcycle to the informant. First of all, receipt of the affair, police registered Pocketguns previous case number 50/2026 under the aforementioned sections. Section the learned counsel, I think the accused applicant submits that the accused applicant is totally unaware that the submits that he has purchased the vehicle from one Jahangir Alam and was totally unaware that the said vehicle was a stolen one and sold to him with fake registration certificates. She submits that the accused applicant will cooperate with the investigation if some protection is granted by this court to the accused applicant. CD in the instant cases has been received in the same is there is learned APP SH Bora, SH Bora has opposed the pair of bail of the accused applicant, taking into account the materials available in the case diary and having found implementing materials against the accused applicant. This court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant every application is dismissed.
That matter,
Is that his come?
one track my road was the Tilak, coming from West Bengal to Tripura. On the road by the mountain there, the Difu, Dimasa, it fell down with some materials, my lord, about 3 MT bar, that was about 30 ton, my leg, 34 ton. My. So it fell down. Driver and handleman was there, my lord, pit number 2 and 3. Number 1 is the owner, he was not there. They somewhat they came injured, they informed the police and owner, pit number 1. Subsequently, the police came after 7 days, my lord. In the meantime, my lord, about major portion of the materials were already missing. 22 out of 34, my lord. Missing, and that only, my lord, 12 kg remains, my lord, received. 12 ton they have received.
So informant is the owner of the,
No, transport company,
owner of the consignment,
company.
consignment.
Owner is the petition number 1.
Owner of the vehicle is petitioner
Petition
number
number
one.
1.
And these 2% driver and
Person
handyman.
driver-
And allegation is that, I mean, they have sold it, I mean,
They have not stolen all the.
faking the accident,
Yes. my lord.
faking the accident.
Yes.
What is there?
They are manual. For the manual, CC manual, petitioner number 2 and petitioner number 3 manual.
They are driver and handyman.
Driver and handyman.
Hmm.
They are getting TMT bar. There is no dispute. But apart from that, nothing is found. I to the city. And even if there is the statements are also recorded of these two men. I have already trackmarked those one. Regarding the petitioner number 1 submitted that the owner his part working in the city dispute. Only in the Caesar list some documents Aadhaar card, PAN card, prove that I have
No, what about these 2 persons involvement? Are they involved?
This in their investigation did not reflect anything. Even their statements are available in the city.
What they are saying, the same thing. What
They are saying that there is the accident.
and TMT bars.
They inform somehow they able to save their life and they got it.
And like who has stolen those?
That part is not yet at this stage
Between gap was 7 days, my lord, from the date of accident and the police came. Registered local person I have taken away, my lord. That all from it. After 7 days, police came, case was registered.
No,
This 2 and 3.
what happened to 2 and 3? They were in hospital or what?
No, they're not that.
After accident, they left the place.
They appear with the police. They themselves, we have stated, my lord. They inform the police. My lord, custodial integration, everything is my lord, the major questions here, my lord.
Third, Mr. H.R.S. Chaudhary, the senior counsel, assisted by so-and-so. For the applicant, also heard Mr. K.K. Bashir, learned APP for the state.
My one PS. My one, man.
Okay, this is an application under section 482 of BNSS 2823. Paying for granting pre-arrest bail for accused applicants in connection with Maibong police case number 07/2026 in bracket GR case number 107/2026 bracket complete registered under sections 61 in bracket 2 stroke 318 bracket 3 stroke 324 bracket 5 stroke 3 bracket 5 of BNS. An FIR was lost by one Ravi Shankar Singh, representative of Sri Balaji Transways before the officer in charge of Maibong police station on 19/7/2026, alleging entirely that the named the FIR named persons suspected to be involved in the illegal misappropriation of a consignment under the guise of a road accident. It is alleged that on 1/7/2026, a truck bearing registration number AS01 SC 5744 was loaded from Pachim Bardhaman, West Bengal with a consignment of TMT bars weighing 35.4 tons to be delivered in Kowai, Tripura. And on 12/7/2026, the informant received a call from Maibong police station informing them about the truck that the same had fallen off the mountain in Kalachan, Assam. It is alleged that 12 tons of TMT bars were recovered out of 34 ton, and 22,040 cases of TMT bars were missing. It is alleged that the petitioner number 2 and 3 and alleged that accused applicant number 2 and 3 conspired to save the remaining bars somewhere along with the road between Salapur and Kalachan with collision with each other, thereby causing substantial financial loss to the employee. On receipt of the FIR, the police registered Maibong Police Station case number 7/2026 under the aforementioned sections. The learned senior counsel, HRS Forgery, learned senior counsel, appearing for the accused applicant, submits that the accused applicant number 1 is the owner of the truck which had met with an accident. He submits that the accused applicant number 2 and 3 are driver and handyman respectively of the vehicle which met with an accident. He submits that while proceeding, while going towards Maibong, the truck met with an accident, and the same had fallen off the road, causing injuries to the accused applicant number 2 and 3. He submits that police was informed in time by the accused applicant numbers 2 and 3, and their statements have also been recorded by them. However, the police reached the spot as many as 7 days later, and therefore it may happen that the goods have been stolen by some miscreants. He submits that there is no intention. He submits that the accusations against the accused applicant number 2 and 3 are totally false, and they have not conspired. They neither conspired nor sold any TNT bars, any of the goods loaded in the truck. He further submits that the accused applicant number 1 is no way involved in the incident case, being the owner of the truck. Therefore, he submits that he submits that the accused applicants should be granted bail, anticipatory bail at this stage. CD in the incident case has been received and the same is produced. After considering the materials available in the CD as well as the submissions made by the counsel appearing for the respective parties, this court is of the considered opinion that the accused applicants should be granted anticipatory bail. Accordingly, it is directed that in the event of arrest of the accused applicants by the investigating authority in connection with Maibong Police Station case number 7/2026, they shall be released on bail on punishing of bail bond of rupees 30,000 each with a severity of like nature to the satisfaction of the arresting authority, subject to the following conditions. Interconditions and in terms of the aforesaid direction, the instant ABA petition is disposed of CD to be returned.
Let's do.
56, very high.
Mm.
56.
Pass it over for time being.
Admission.
My lord, earlier in this case, for the respondent, the legal aid counsel was appealed.
You are appealing for whom? Respondent earlier.
Legal aid counsel was there, also, as
Okay, now you have been engaged. Okay, yeah. You have the copy. You have received the copy. When did you file the wakalatnama? Today itself. So you need some time. So you want to do the argument today? You have gone through this. Okay,
Lordship,
argue.
Lordship, I'm not ready, in fact, because
Why
it-
she is ready, you are not ready?
no, Lordship, in morning we are supposed to make an mention we tried to contact the earlier legal aid counsel. He informed me over phone that he is no longer in this. So we,
Okay,
but there is another development also.
hmm. He's saying that like he wanted to mention the matter and he already contacted the other side.
And I didn't know that she is engaged also.
See, he doesn't know that he doesn't know that you are appearing. What is your name? He was not aware, otherwise he would have probably been.
Also, may I submit something? Also, there is another litigation pending between the same parties. Also, Mad Appeal 31 of 2022 laws. And in that case, as ordered by the Honorable Court, we submitted our respective assets and liabilities affidavit also. The case, the matter is about to be heard. And the both of sides, in that case, I am not appearing also. Both the sides are making their effort to settle the issues amicably also, what I am told by my client also. And that's why considering that development, also, I am not prepared today. Because as I'm told also, because
She's shaking her head violently.
But as I'm told also, she is a practicing advocate now. And the
Who is an advocate?
the respondent also.
Okay.
enrolled advocate like me, just like me. The condition is very good. Lordship is in severe financial distress. This has been pending since a long time.
Long time means?
Or the trial court has given the order of maintenance. It was upheld by the sessions, court of honorable sessions, court of Gauhati. Again, in that matter, because this means the case filed for divorce was dismissed by the honorable district and session judge Sixagar with cost not.
This appeal is filed under which provision by
The
you?
480, this.
No, I'm asking her, which provision, under which provision you have filed this appeal? For what? For what relief? For what relief? It is filed by him. Or you? He has filed it.
Granted is interim maintenance of 1,000 rupees only, which is not at all. It is not at all possible to sustain myself in such a labor.
You are a lawyer, why do you need a maintenance?
Lordship and doesn't mean and
Newly enrolled advocates are very rich these days. They come on cars, not like earlier times.
Lordship, not true. Her condition
No,
is very
it's true,
well.
it's true.
She has
We can see all newly enrolled counsels coming by very luxury vehicles.
no, that
It's
is
not like earlier times.
that is not the real image.
And you are a lawyer.
That is not.
Okay, we'll give him some time. We'll give him some time.
Lordship, I pray with folded hands for a.
No,
very
please don't
short-
do it. Please
short
don't.
period.
This is not a place to
Short
like
day.
you fold your hands. This is not a
Short
place
day,
to fold
short-
your hands. Don't do that. We consider everyone's plea. So like in consideration of his plea, we are granting him some time. Mr. D. Das.
Yes.
What Mr. D. Das, the learned counsel, the petitioner also heard your name.
Ji Borua.
G. Burua, the learned counsel appearing for the respondent. Mr. D. Das submits that he has some personal difficulties to do the case today and pays for. When do you want to do it?
Lordship, it's for the convenience of this honorable court, after a week plus.
Hmm?
After a week plus.
Okay, he prays for 1 week's time. Let the matter be listed on. 9 September.
9 September, I have some difficulty, Lordship. Can it be prior or later?
Then make it on 10 September.
Lordship,
Look.
prior to that.
10 September.
Lordship,
God bless you.
Lordship, there is an interim order, Lordship, that.
The interim order so passed earlier. We can continue till the next day.
Lordship. In this case, I have newly enrolled minor earlier discussed was by other set of counsel minor. And service has already been completed. I need some time to prepare and I have to take some instruction on it.
And I am
10 days, my lord.
on behalf of the opposite party, my lord.
Respondent
Respondent number 2, my lord. My lord, time may be granted that I have no objection, but direction may be given to pay the amount, my lord. He is taking advantage of this pending case, my lord. He is not paying anything, my lord.
Without hearing, how can I give it the direction?
My lord, the regular monthly maintenance, he is not paying, my lord.
My lord,
Why
is it a-
paying?
No, I have, it's an ex parte
And-
order, my lord, 10,000 has been granted. My
Okay,
qualification.
on the prayer of the learned counsel appearing for the petitioner, let the matter be listed on.
No, 10,000.
11 September. 11 September and mark his presence. What is your name?
M. Rahman.
M. Rahman from.
M. Rahman.
M.
M.
M. Rahman is learned counsel is present for the respondent.
But by this petition, we are challenging a domestic violence case order passed by the CGM Borbota lordship. The order has two parts. One is husband directed to maintenance 6,000 per month, and second part is husband and relative or husband directed to pay the compensation of 2 lakhs. We are challenging only the compensation part, and relative of husband before your lordship, the husband is not challenging order lordship.
Husband is not,
Not challenging the order.
who is challenging the order?
Relative of husband.
Relative, how can do it? You can do.
Lordship. Relative of husband directed to pay the compensation, domestic violence.
Relative of the husband is the directed.
Yes,
How?
let's have a look at page 26.
Huh? Is
26 question.
But my lord, as per the last order, your lordship, the petitioners are directed to pay the amount of 2 lakhs, your lordship, and the monthly amount of rupees 6,000, my lord. But still there, no one installment has been given. But they are taking time before this,
which order was that?
my lord, 23 to 2026. In this case, they were already
NPW was issued.
issued.
Issued
Only
PSA.
NBW considered.
Huh?
NBW recall lordship.
Recall
Recall.
on the condition that
On condition to,
no stay order. The,
yes, ma'am.
the matter is still going on there.
Yes, my lord.
Hmm?
Yes.
And which is the direction for payment?
But my lord, but in the lower court, they have been taking time for give them money, your lordship. But still that no installment has been paid to me, your lordship. All,
The maintenance.
this,
Why are you not challenging, not challenging? But that if you are not challenging, then we are not paying.
yes, yes, my lord.
Yes,
This,
that may be paid. That may
Where?
be paid by the husband.
You are not paying. That's why. That's what he is saying.
Lordship, husband is not before your law.
husband part is, your lordship, 6,000 per month.
Huh.
This is the maintenance, your
So
lordship.
he is paying or not?
No, my lord.
He is
Husband
not
also
paying.
not paying to me,
Yes.
and the petitioner.
Husband.
You are not bothered.
No.
Why? Because you are the relative of the husband. You were also involved in domestic violence case. That's why
Yes.
compensation was. I mean,
We
asked
are-
to be paid.
Lordship, we are the relative of the husband. Relative of the
So relative.
victim husband.
So let me see the order.
Yes,
Impugn
sir.
order.
At page 26.
Page 26.
Yes.
Yes. Like where?
May I read lordship last portion order?
Hmm.
In result, the respondent of one shows
Where?
last portion lordship is 26.
No. I mean, we'll have to know the facts.
Next lordship.
Respondent number 1, 2, 3, 4, 8. How they are involved?
Oh, respondent one is husband.
Hmm.
Respondent one is husband. 3 is father-in-law. 4 is brother-in-law, and 8 is sister-in-law.
Who is challenging this now?
Now challenging father-in-law, brother-in-law.
So father-in-law is a relative. You say father-in-law is a relative.
Yes, ma'am. Father of the
petitioner
petitioner.
said that they are related. The husband and the petition said that they are related. Their ground is the ill advice of the relative husband harass the victim.
Husband and a relative.
Yes. No,
Relative means
relative-
father-in-law.
Ill advice of the relative husband harass the victim. That is their allegation.
Hmm.
And my stand is
This is the omnibus allegation. There is no specific allegation to the relative.
What is omnibus? I don't understand. What is that?
Lordship, they said, ill advice. So if it is a specific allegation should be there. It should, if it is a specific, then what is the advice? When it made the advice? What is the effect of the advice? There should be mentioned also. And it's a guideline of the Supreme Court. And Supreme Court said that on the basis of omnibus allegation, a relative cannot be roped in a matrimonial case.
PCR is not required in this case.
Lordship,
PCR will not be required in the case.
LCR is not.
Why LCR is not called for?
So everything annexed there.
Hmm?
Everything has been annexed.
Everything annexed is different thing. Why LCR will not be required?
The LCR may be called for, in the meantime, we will file our
Our,
affidavit. only.
Lordship, our query entire amount may be taken from the husband. We have no option. Where the father, brother, and sister-in-law. So, and we are living separately.
We'll require a TCR in this case. Without TCR, well, how we can hear this?
Yes, ma'am. This is-
And let them file also their own this thing.
yes, ma'am.
My query is, stay may be the only for the second part, otherwise warrant will be issued.
Hmm?
Lordship, the compensation part only stay.
That is what is requires to be stated.
Lordship, maintenance, we are not challenging the maintenance.
After, I understand, after hearing you, in, that on interim order was passed. Interim order was passed that like NBW has been withdrawn. And you, and compensation party also stayed. What else you want?
Lordship,
What else you want? And without the TCR, how this matter can be heard?
now NBW is recalled, Lordship.
That's what I'm saying. NVW recall and compensation. I mean, as far as you, the compensation is stayed. Then what do you want?
Lordship,
No, my
compensation is
compensation not
stayed.
stayed.
It's stayed.
No, my lord. Kindly come on page number 3 of the
Yeah.
last order, your lords.
Therefore, I am paying you.
Last paragraph. However, there is no extra order passed with the regard to the order compensation passed by the landed trial court, your lords.
Oh.
Lordship, I pray only the compensation part may be stay till disposal of this order.
No,
And
no, if
maintenance-
the interim order once passed is passed. I mean, I cannot consider it again.
Yes,
Let the TCR come. TCR, why TCR was not called for? Without TCR, how the matter can be heard? This is a revision petition.
but my lord, yes, my lord, the matter may already been fixed on 28/8/2026, your lords, so for payment, your lords. This is the execution, your lordship. Money is. TCR may be called for it. TCR may be called for.
Yeah.
The learned counsel appearing for the petitioner also heard.
I am S. Islam, your lords.
MS Islam, the learned counsel.
Respondent number 2.
Respondent number 2 and MS SS Bora for respondent number learning deputy for respondent number 1. Let registry to call for the scan copy of the TCR in the instant case. From which court?
CGM Borbeta.
TCR in connection with CR case, no?
Yes, yes.
CR case number 523/2023 from the learned court of additional CGM Borbeta. Let the matter be, when is the next date?
28/8/2026, your lords.
28/8/2026.
So in the meantime, my maintenance may be clear. your lords.
It takes some, time there if you.
After 20.
Maintenance, you argue there, why you are saying it?
Yes, my lord, they have taken time, your lordship, by
Now you say there, you say there.
petition. Your lord.
Let the matter be fixed. On 16th September.
Okay, sir. Okay. Highly office.
Please, Your Lordship. Lordship, despite the notice issued and steps been taken, the private respondents have failed to appear in this matter. And also the LCR records are not on record today, Lordship. The LCR records are also not on record, Lordship.
LCR not received.
LCR not received, Lordship.
TCR not received. Your name?
Please, like Your Lordship.
B. Saikia is present for the learned petitioner, as well as MS Ashish Bora is a learned APP is present for the respondent number 1 or 2.
Lordship, we are
Respondent
very
number
good.
1. Respondent number 1. Then you write. None appeared for the respondent number 2. Notice was served.
Yes, Lordship.
Have you checked the record?
Yes, Lordship. And even the steps have been completed, Lordship. We have checked.
From where you are saying the notice has been served?
Lordship,
In the earlier occasion, it was awaited. Service
Hmm?
report was awaited in the earlier occasion.
How are you saying notice has been served?
Lordship, in the matter notice was served and we have taken the steps, Lordship. We have
No,
taken the steps.
but taking steps doesn't mean that the notice has been served. Who is the senior?
Lordship, actually, I was saying the notice was issued in this matter.
Notice is issued. That's a different thing. I mean, whether it has been served or not. Once it is served, then only somebody will appear. Notice is not served in this matter as yet.
Check the records. I was informed as such, but I'll check.
You should do it beforehand.
Yes, Lordship.
The notice is presumed to be completed.
Lordship.
Notice is presumed to be completed. Okay, notice is presumed to be completed.
Lordship.
Then you write, none appeared for respondent number 2 in spite of notice. Yes, TCR is yet to be received. Let the matter be listed on 23rd September.
Lordship, there is also an interim order that may be continued.
Interim orders passed earlier and continued in the next detail listing.
Even though-
Lordship, as for the other side, they have informed that they will take time to file the additional affidavit.
I will file my additional. Today I appeared, my lord, for respondent number 2, my lord. So I will file my affidavit in office.
Okay, Mr. So-and-so, learned counsel appearing for the respondent number 2.
My lord.
So why additional affidavit?
There are some issues, my lord.
Affidavit in opposition? you are filing?
Opposition.
Submits that he submits that he requires 2 weeks time to file an affidavit in opposition in this case. MS P. Bora, M. Bhuya is present for the petitioner. MS SH Bora, APP for the respondent number 1.
Yes, Doctor.
Respondent number 1. Let the matter be listed after 3 weeks.
Lordship, here we have received the case study.
Hmm?
It will be retained or presented?
Case diary.
Yes.
Why case diary?
It's a criminal petition, my lord, challenging the quashing of FIR, my lord.
Washing of the FIR.
Yes,
My lord.
Lordship.
You are filing an objection, that means.
My lord.
Right, objection.
Objection, my lord.
You are appearing for the,
I am for the informant, my lord, respondent number 2.
then why is respondent number 2 informant? Okay. Objection, right, and like CD to be retained, let the matter be listed after 3 weeks.
Hello.
After 3 weeks.
Or you can bring in updated CD,
Yes, Lordship.
that will be better.
Yes.
You write CD to be sent back and the updated CD to be produced before this court on the next date.
Obliged.
19.
Lordship, the matter has been settled between the parties. The fine amount has already been paid. My prayer is to set aside the imprisonment.
Where is that settlement?
Lordship, the settlement, it's in page 38. We have attached the
Who is for the other side?
Lordship,
Who is for the other side?
S. Upadhyay.
Where page?
Page 38. It's an acknowledgement receipt.
No, if that is so, why have you filed this petition?
Lordship, in appellate order, the trial order has been upheld. After that, we have come for it was upheld. After that, we have come to the settlement. So the other party has no issue if the imprisonment get set aside.
Imprisonment gets settled. Then let the other party come, we'll see. Let them, MS hearing,
M. Day.
M. Dev. M. Dev is present for the petition. Have a none present for the respondent number.
So
Respondent number 2. When the matter was called for. No, only one respondent.
respondent.
So none appeared for the sole respondent. Let the matter be listed after 2 weeks. Or 2 weeks, maybe 2 weeks.
Your Lordship, this is a legal aid matter and I am appearing on behalf of Mr. S. Biswas. Steps has been taken up in respondent number 2 through the learned PP, but it is still awaited.
Approximately.
The petition.
Delay petitions.
PP couple this letter. Respondent number 2 service order for the PP. Yes, certainly.
So we'll take instruction whether.
Last time also it was the same direction.
Lordship.
MS, right, MS your name?
D. Devi.
D. Devi.
D. Devi.
D. Devi is present on behalf of Mr. S. Biswas.
S. Biswas.
S. Biswas, the learned legal aid counsel.
PS case to revoke that. This case to
Though the notice was issued,
the listing.
respondent number 2. So the office of the public prosecutor, the office of the PP. No report has been, no report of service of notice is received as yet. It is by MS SS Bora, and APP is directed with instructions about the service, about the status of service of notice upon respondent number 2. Let the matter be listed again. Let the matter be listed on 16 September.
Lordship.
45. Lordship, the respondent number 2 has appeared. They have filed a wakalatama today. I've seen in the court.
So we will file objection, Lordship.
Okay, heard Mr. H. Roy, the learned counsel. Your name is there in the wakalatnama?
Yes, your Lordship. J.K. Wright's there.
Okay, heard Mr. J.K. Roy, the learned counsel appearing for the petitioner. Also heard S.S. Bora, learned APP for the street. as well as Mr.
Yes, Ali Lordship,
S. Ali, the learned counsel, appearing for the respondent number two.
two, yes.
Mr. Ali submits that he requires 2 weeks time to file an objection in the instant.
The matter may come up for admission hearing, Your Lordship.
You have filed IA for what?
We haven't filed IA, Your Lordship. Item 45 is IA.
Okay, you need petition.
Lordship, the scanned copy of PCR has not been called for yet. It may be called in.
Scan copy will be required in this matter.
As a Lordship deems fit.
What is the matter all about?
The matter belongs, pertains to quashing of an FIR, Your Lordship, where an old man has been mentioned as accused number 2 in the charge.
FIR, then like what happened? I mean, trial is going on.
The trial is going on, Your Lordship. He has
What-
been
what
implicated as
stage?
accused number.
What stage?
At present, the charges are yet not framed, Your Lordship.
Then a TCL may not be required.
As a Lordship deems fit.
Let the matter be listed after 3 weeks.
Lordship, there's an interim, it may be.
Interim order so passed earlier shall continue to level 3.
Highly obliged, Your Lordship.
Obliged, Lordship.
26.
Earlier, because another should be directed to after station for virus and it so there are some application number 2.
46. Okay, Coxo.
No bit to can but regular service of national number 2 last.
Mhm.
And if you ask to that we should kindly put the order date is 7
Coxo.
7/8/23. Earlier order.
You take instructions.
Yes, Lordship. On a PS test number, PS case number 2.
Yes,
Heard Mr. A.K. Ahmed, the learned counsel,
Convenient accusation.
applicant, and MS SH Warrant, the learned Assistant Public Prosecutor for the state. Though notice was issued to the respondent number 1, respondent number 2 to the office of the TP. No report of service of notice is yet received. The learned ATP SH MS HS Warrant is directed to get the status report about service of report. Service
They're in jail lordship.
service of notice and respondent number 2. Let the matter be listed after 2 weeks. After 2 weeks.
Lordship.
That's a picture, he is in jail lordship.
After 2 weeks.
Yeah, command, লিখিলো না এটা command of.
May please lordship, the TCR model already has received. So far, office note reveals the service upon respondent number 2 to 5 has yet not returned. And it was within the corrected. So far, their address appear in the document. So if correct address by speed post, is it to be served somewhere? Because answer notice has yet not returned back. And their address appeared in the judgment.
Then we'll wait for some time.
Lordship.
Heard Mr. K. Bhuyan, the Learned Counsel, paying for the appellant. I saw heard MS SH Bora, Learned ATV for the state service report is awaited. Let the matter be listed after 2 weeks.
TCR received by the
Hmm?
TCR already been received.
You said receipt. You said already there. So 2 weeks after.
Wait for some,
Hmm?
wait for some days. And
2 weeks, let 2 weeks. But I mean,
date maybe takes months.
service has to be done.
Date maybe.
2 weeks, 2 weeks.
Obliged. 48.
Yes, please. Lordship, kindly allow me to take fresh step.
You have not taken steps.
Yes, Lordship.
There was direction to take steps,
Yes,
steps.
because of taken. Kindly allow me one more date.
Your name?
M. Rahman.
M. Rahman, the learned counsel appearing for the appellant submits that that sometimes should be granted to him for taking fresh steps for service of notice. Notice upon one, who,
Two, Lordship.
on respondent number please. Let the matter be listed after 3 weeks.
Obliged.
49.
May I pay your lordship? Lordship, we have taken steps upon respondent number 2, your lordship. This year I have not yet been received.
You have not taken steps.
Taken steps, your lordship.
No, you record
We have taken
steps.
steps on 14/8, your lordship. 14/8, on 14/8, your lordship.
14/8,
Yes, your lordship.
but there is no updation of the record. Right, your name?
Yes.
A. Das is present for the appellant. And S.H. Vora is present, natively for the state. PCR is not received. PCR not received. Let the matter be listed after 3 weeks. 3 weeks, not sure.
May I praise the Lordship? I have taken step for respondent. Taken step for respondent as 14/8/2026.
You have not taken steps.
We have taken step.
When?
Respondent two.
When you have taken?
14/8/2026.
14/8. Okay, your name?
A. Sharma.
K. Sharma. K. Sharma, the land counsel is for the appellant. Bora is for state. Then you will PCR not received. Let the matter be listed after 3 weeks.
Obliged.
51.
May I please your Lordship?
Hearing the number.
May I please your Lordship? I am appearing for the petitioner, my Lordship, in this matter, my Lordship. As per the office note, my Lordship, the service has been completed in way back in the month of June, my Lord. And my Lord, this CR case is pending, my Lord. I'm sorry.
Mr. So-and-so is present for the petitioner.
May I please your Lordship?
Office note dated 13/8/2026 reveals that that notice has been delivered to the address on 19/6/2026. However, none has appeared when the matter was called for. From call for on behalf of respondent number 2. S.H. Vora is present for the respondent number 1. Yes.
My Lordship, this is a criminal petition, my Lordship, between two brother-in-laws, my Lordship. And this is, which is like epicenter of this case, my Lord, because of a Volvo vehicle, my Lordship. And my Lordship, although my Lordship notice has been issued, my Lordship,
Let
this
them
TCR has
appear.
not been called for, my Lordship, in this matter, my Lordship.
Mhm.
And this, all the cases have been arising out of civil dispute, my Lordship. It's a case of, my Lordship. It's an appropriate case for stay, my Lordship. I'm praying for, my Lordship, one more submission, my Lordship. In this
No
matter.
submission.
TCR may be called for, my Lordship, and in the meantime, stay may be granted, my Lordship. Because in the same parties, my Lordship, when order has been passed, my Lordship, in another, in page number 117, my Lordship.
Registered a call for the TCR in connection with CR case number 5. CR case
My
number
lord, my lord, my lord.
24 from the court of
Distributors, my Lord.
learned judicial magistrate first class Dibrugarh. Let the matter be listed after 3 weeks.
My Lord, one more submission. My stay may
No
be
submission.
granted. My Lord, stay may be granted.
No stay granted.
My
No
Lord,
stay granted in this.
within the same parties, my Lord.
I know and I have seen that.
Highly obliged, my Lord. I'm grateful.
TCR will be called
next
for my lord.
order after TCR will consider.
My lord, my lord. This may be reflected, my lord. Interim will be
3
considered
weeks,
like
3
that.
weeks, 3 weeks.
Highly obliged. I'm grateful.
My lord, in this case, we have filed an IA, my lord, for directing the registry to release the 20% compensation amount that was deposited by the petitioner, my lord, pursuant to the order of the honorable court, my lord. The petitioner was convicted under 138 of the NI. He filed appeal that was dismissed. He filed revision before his honorable court. And during revision, my lord, he was directed to pay 20% of the compensation amount. So to my knowledge, he has deposited the amount, but
You have
as in the
deposited?
order,
Yes, your lordship.
as in the order, it is not reflected that it should be paid to the present respondent. So registry is not releasing the amount. Order is annexure 1, my lord, page 7.
Lordship, we have the demand draft amount for the amount paid.
Release.
Yes, your lordship.
Heard, Mr.
I should.
It will be done in council appearing for the applicant. The instant application. I also heard.
FB Chaudhary on behalf of Mr. A. Ahmed.
Use an application for releasing 20% of the compensation amount in favor of the respondent applicant, which is deposited before the registry by the petitioner. Pursuant to the order dated 5/5/2026 as in IF in bracket criminal number 455/3026. The learned counsel appearing for the applicant submits that though the money has been directed to be deposited before the registry, that order dated 5/5/2025, there was no direction passed to the registry to release the aforesaid 20% amount on receipt by the registry. On receipt of the registry to the respondent, to the respondent, to the applicant respondent, to the applicant stroke respondent. The learned counsel appearing to the respondent has submitted that the petitioner had the learned counsel appearing for the petitioner is submitted that 20% amount has already been submitted before the registrar or the high court to provide demand draft. Provide a demand draft dated 1/6/2026. 1/0/2026. The learned counsel has submitted a copy of the same and the same is kept on record by nothing else. View of the aforesaid deposition, and the registry is directed to release the aforesaid amount of aforesaid amount of 20% of the compensation. Compensation to the respondent applicant. To the respondent applicant first. In view of the aforesaid direction, the incident I is disposed of.
Alright.
Light, Your Lordship.
Orders.
Your Lordship, the service report is still awaited as respondent number 2.
Okay, office from the 14/8/2026 reveals the service report is still awaiting in respect to respondent number 2. Unless,
DR Bongshari.
huh?
DR Bongshari.
We are once here is present for the appellant. Yeah, for the appellant. Appellant present, and unless this is one reliability is present for the state respondent. Let the matter be listed after 2 weeks. 2 weeks.
Much obliged. Yeah, please, Your Lordship.
Please forward, please come forward, 58.
As
Yes.
per the last order, the objection filed by the respondent was not tagged with the case record, so registry was directed to take the same with the case.
They have received our objection and we have already filed it long back.
Written objection is filed on 3/8/2026.
Yes, Your Lords.
It is already there.
It
so
is
we will
already
put it
there.
For
It's a
admission,
very small issue, Your
we
Lords.
put it for admission.
But the thing is that is
No, this is
still,
for orders, we will not take a orders matter, and we will put it for admission.
then a sorted may
Our
kindly
third
be given.
is
T. Mishra.
P. Mr. the learned counsel appearing for the petitioner, also heard MS M. Kumari, the learned special, learned standing counsel, CVL. Let the matter be listed in admission column after 2 weeks.
A date may kindly be fixed, Your Lordship. Because it's,
Let the matter be fixed, one. Fourteenth of September. 14th September.
it would be long, Your Lordship.
No, the other one. Board is.
Because
full.
they have taken the stay at the last stage when argument is completed.
They got full, board is full.
14th,
14th.
then 14th, on 14th of September, I may not be there, that is.
Then 15th,
15th, it is okay.
15th.
Much obliged.
Deeply obliged.
None appeared for the. Okay, nobody is appearing for them. Mr. A. Gayan. Who is A. Gayan? No, not you.
Oh, Mr.
Are you appearing?
Mr. Egan.
Mr. A. Gayan.
Yes.
None appeared for the accused applicant when the matter was called. It is seen from the records that on the last 2 occasions also none appeared for the accused applicant when the matter was called for. In view of the episode, the instant AB application is dismissed. MS HS Bora, Leonard APP is present.
Lordship, CD call for that we have received.
A CD call for a CD to be returned.
Lordship.
Wait, please, Your Lordship. Item number 54, my lord, we have some urgency in this case, my lord. One of the petitioners is working in IIT Kharagpur and she is in probation, my lord, and she is going to lose her job, my lord, because of this case, my lord. Where she has no involvement in this case, my lord. Kindly take it the matter tomorrow or day after tomorrow, my lord.
Okay, day after tomorrow we'll
Day
try.
after tomorrow, my lord.
54, item number 54 is right. MSK Gayan is present as for petition. You were there. LDP is LDP. MSK LDP is present. And let the matter be listed. On 19th.
Can it be possible to get at to my lord first?
That too difficult, but we try. Huh?
Yes, ma'am.
19. Let the matter be listed on 19. Yes. 53, anybody is there? I'm hearing. Your lordship, short sentence of 5 years. Perhaps lordship may fix a date. Otherwise, matter is ready for hearing.
Okay, Mr. A after is present for the accused, for the appellant. MS SH Bora is APP is present for the state. And Mr.
I am appearing on behalf of Mr. A. Fukon.
Where is Fukon?
Fukon sir is, your lordship not able to come today. He is some technical difficulty.
Amicus curiae should personally present, huh? They should not be represented by somebody. They should
Lordship-
always present themselves. Then you write, Mr. Your name?
Aminul Hussain.
Aminul Hussain is present on behalf of Mr. A. Fukon, Durrani Amicus curiae. Let the matter be fixed on when?
Any date convenient.
Maybe the
Next
month
week,
of
dear Lord.
September.
Correct.
Let the matter be fixed on 15 September.
Okay.
15 September. Some orders being fixed.